Together. Commercial appeal matter, my lords, requesting for admission.
Madam, commercial appeal memo. Commercial appeal memo. Lastly, 2023 May post ಆಗಿತ್ತು my lord because of money ಇದೆ. Money transaction. It is for money transaction, my lord. Commercial appeal.
When it was listed?
It was 2023 May, my lord. It lastly posted.
Commercial appeal memo, my lords, it was listed a month back. Office objections were there. I have cleared it, and the lords had ordered to deposit the entire decree amount. That also we have deposited, and notice also we have. So I have
Was
it.
there any date given?
No date given. No.
Mistake that. Sir roster. no?
Two commercial appeal matters, my lord. We have for the appellant in both of these matters. One was last listed on January 2023. And the other one was in September 23. It hasn't been posted since.
Yes, ma'am. Both are connected.
My lord,
Both are connected.
I.
They connect.
Both are connected.
Yes, yes, my lord.
Okay. Just give it. Just give number. Yes.
Income tax appeal. Covered by two decisions of the Honorable Delhi High Court. Immediate convening to my lords can be fixed.
Monday.
Any Monday.
Then just check up our board on Monday or let it be there after next week. No, not 4/11. Then make it 11th. We'll have it on 11th November. Yes, ma'am.
Mention a matter for adjournment.
No, then we'll call the list.
For adjournments, page number 2, 8 and 9. Page number 3, 11, 10 to 12.
Translation and the citations in the
Number 11. We appeal for respondents 1 to 4.
Translation of which annexure?
Sir, from Kannada documents are there last application was last directed me to file translation.
Oh.
That I very
You have any objection on that?
No.
The counsel for the appellant seeks and is allowed 4 weeks to file English translation of the Kannada documents.
Synopsis also on the citation.
The counsel shall also file their written submissions
Oh,
along with the judgment they want to rely upon within the same time period. A list on
11, 12.
What?
Page number 4. 13 to 19. Page number 5.
Serial number 19, my lords, I appear for the appellant.
this 11 was 319, huh? Our MFA.
3906.
Lords,
Which
serial
number?
serial number 19, I appear for the appellant, my lords. Lords, a senior is traveling on this day, my lord. It may be taken up next day. It may be taken up next week, any date.
On several
30th.
occasions, this matter was listed before the court for final disposal, my lords. For final disposal. I am ready to address our argument.
Only
What is
request
the
is,
difficulty?
my lords, senior is traveling, my lord.
Senior is,
Traveling.
just say that adjournment is sought by the counsel appearing for the
Appellant.
appellant. In both the matters,
Yes, my lord.
on the ground that the arguing counsel is in personal difficulty, re-notify on, just give it in November somewhere 3rd or
30th may be given, my lord.
1911.
30th of this month.
counsel for the parties to file their written submissions, if not already filed, before the next date of hearing.
Sir, 1911.
Next,
Number 5, 20 to 23.
My lord, serial number 20, my lord. I appear for the appellant.
which number, ma'am?
Serial number 20, my lord.
Yes,
Kindly have it next week, my lords, due to some medical emergency that my senior is unable to appear.
so we can hear it. Whose difficulty, ma'am?
We've engaged a senior counsel, my lord.
You are engaging senior counsel.
You appear for the respondents. Have you informed the other side?
My senior has informed the other side.
Adjournment is sought on the ground that the counsel is, the arguing counsel is in what medical, is unwell. Unwell?
Please,
Okay. Next,
1712. Page number 6. 24 to 26. Page number.
Serial number.
next, ma'am, next page, just call.
26, my lord.
You are in 26, yes, ma'am.
Responded, my lord. May I request for 2 weeks' time in this matter? It was listed last in December of 2023.
Who? You are for the respondent?
Please.
No, but have you informed the other side?
In fact, the appellant called us this morning, my lord, and they informed us that they've given NOC in this matter, and the new counsel is required to file their wakalat, which has not yet happened. So
Then let the
therefore,
matter be called. Just wait.
Please.
Yes, ma'am.
Page number 7.
Serial number 24, my lord. 24. I appear for respondents 1 and 2.
Who is the other side?
Other side is Mr. Rajeshwara PN. I have informed. I am suffering from,
Appellant in this case, serial number 24.
I am suffering from shingles, which has affected my right eye.
The counsel appearing for respondent number 1 and 2. You are for 1 and 2 only?
1 and 2 only.
It's all right, it's all right. Seeks an adjournment which is not opposed, re-notify.
1612.
Mr.
1612, sir, December, 16th December. Page number 7, 27 to 31.
Yes, ma'am. All the list.
Serial number 1.
Hello.
Government advocate.
For the appellant state, my lord.
Yes, what do you say?
Lords, the interim order granted by the learned single judge.
You are for the respondent?
Yes, your lordship, but only
Yes.
my submission is that, your lordship.
What
Yes.
happened to the proceedings have been initiated?
My lords, under section 130, I have confiscated the goods, my lord. I have come to the conclusion that there is intent mens rea to evade tax.
May
And
I
I
make
have-
only one submission, your lordship? Your lordship, they have served a copy without even pagination, your lordship. So
How much is the total liability?
your lordship, in this.
Just see, just show us the interim order.
My lords, the interim order, my lords, is talks about
improved
a
order.
deposit of only about 4 lakhs. In the section 30,
Page, which page?
my lords. If your lordship is
Yes.
extracted at page number 9. And the certified copy is available at. Not page number 35. The order is extracted
Yes.
at page number 9.
The page number. 35, you said?
My lords. Order dated 9th of August 2024.
Oh. It's scanned, I suppose. What was the total amount liability? What is the total liability?
My lords, about 25 lakhs. Out of that, a deposit of only 4 lakhs has been ordered.
How much amount is admitted?
My lords, this is a case where I have.
Right.
where I have come to the conclusion that there is intent to evade. My lords, may I just pass on my order
What do you say?
imposing fine?
Your lordship, we have already paid the tax which is liable to be paid, your lordship. And the only issue that arises for consideration in this is that, your lordship, whether they can bypass section 129 and directly issue a notice for confiscation under section 130. That is the question that is,
Suppose it is held against you, then
Precisely.
please, your lordship.
if it is held against you, then
Even then, your lordship, we are entitled for, release of the goods, your lordship, as per their own order,
subject to
subject to the payment of the tax which is liable to be.
the point which is being argued.
Please, your lordship.
Subject to, let's assume, it's not that possibly you may succeed also, you may not succeed also.
Please.
What is being contested is the amount which has been directed by the learned single judge. There should be something which is reasonable.
Yes, your lordship.
It
That
is-
is,
And according to him, the total liability is 25 lakhs.
that is wrong, your lordship, because we have already paid the tax, whatever the tax that is payable. And out of the 3 consignment, your lordship,
What happened to
only,
the learned single judge? Has this been petition been heard?
yes, your lordship,
My
it has been
lordship.
heard. The other side has been heard. They have given a sufficient opportunity, your lordship. In fact, the writ petition was filed long back, and after issuing notice and giving sufficient time, your lordship, the matter was heard for 2-3 days, your lordship. Then only the interim order was passed.
But what is the status of the writ petition now?
It is
Precisely,
still
my lord.
pending. your
Writ
lordship.
petition is pending. My difficulty is that the goods are perishable. My lords, under 130, when I passed the order,
But have you released the goods?
Not at.
my lords, because once under 130, I pass the order, the title to the goods passes to me, my lords.
What are the nature of the goods?
Tobacco, my lord.
Tobacco
That's the
products.
difficulty. If it had been scrap iron or something of that sort, I wouldn't have troubled your lordships for an interim order, because I would have argued the question of law. Here, the difficulty is, if he wants the goods, let him furnish, either make a deposit or a bank guarantee for the remaining amount. Otherwise, my lord, what happens is, otherwise.
Tell us one thing. According to you, it's 25. Let's assume now we are putting the opposite question to you.
My
Suppose
lord.
he has to succeed.
My lords,
Why should there be a huge amount deposit of that kind of an amount if ultimately he has to succeed?
because the statute contemplates it.
That's an argument.
Yes.
Surely that's an argument.
Sure.
Obviously, you can't take anything which is beyond the statute.
My lords,
But suppose the petitioner or the respondent succeeds before the learned single judge. So then what do you say?
my lords, then if I am permitted to auction the goods, I will keep the deposit in the treasury. He will then.
He can say instead of 4 lakhs, what has been said, let there be a 50% of the total amount.
Your lordship, the value of the goods itself is 11 lakhs, your lordship. Apart from that, we have already paid the entire tax.
My lords, kindly see.
That is not in dispute, your lordship. Then
page-
the demand itself is illegal. What they have quantified, it is,
My lords, that there on the demand, he has an appeal. He cannot, my lords, in writ appeal, argue the correctness of my demand. I am purely
Yeah.
on
No, we are only on an interim relief.
Yes.
precisely, my lord.
yes.
All.
Precise. If I may take your lordships to page 65 of the memo that I have now filed,
But tell us, what is the basis for 4 lakhs?
there is no basis.
Basis, your lordship, we have made a submission that the tax has already been suffered. And your lordship, out of the 3 consignment, only in respect of 1 consignment, your lordship, there was no e-way bill. That is because, your lordship, the person to whom I am supplying the goods is an unregistered person. So, I will not be in a position to generate the e-way bill. That was the submission made before the, the learned single judge, your lordship. Because, your lordship, for the remaining goods, your lordship, I have got the e-way bill, even all the documents are in order. It is only in respect of the small quantity, your lordship, that is having the value of 1,10,000. Considering that, your lordship, the
May I
learned single judge has ordered for,
submit-
a deposit of 4 lakhs. Your lordship.
May I submit, my lord? First, the interim order of the learned single judge does not reflect any of this. It just says that the question is kept open. What happens then, my lords, is the memo that I have produced. I come to the conclusion that there is intention to evade tax. I invoke my jurisdiction under 130 of the Act, read with 122. On page 65, my lord, a fine and penalty is levied, my lord. And in fact, under that, my lords, the tax, cess, and fine, everything paid comes to about 2 crores 20. sorry, 22 lakhs 35,932.
But tell us one thing.
My lords.
But even before confiscation, everything, surely something needs to be put to them so that.
It was put to them. Show cause notice is also produced. He seeks time. His submissions are considered. A detailed order is
But
passed.
see, if you go by the learner single judge order,
Yes, my lord.
for respond to complete proceedings, had you completed the proceedings?
No, no, your lord.
My lords, what has happened is that pursuant to an amendment that was effected in 2022, the proceedings under 129 and 130 have been completely disconnected. I'll take your lordships through that, both through the resolution of the council as well as the amendment.
We are only asking this.
My lords,
120, this show cause notice given.
precisely. It is submitted also, my lords.
Is there any final order passed?
Yes, my lords.
When was it passed?
1/8/2024, my lords. It is at page 25 of the memo that I have filed. The show cause notice is at page 1 of the memo that I have filed, my lords.
That is without complying with the provisions of section 129, your lordship.
My lords, that
They
question,
have directly jumped bypassed section 129 and issued a show cause notice under section 130.
even as per the interim order, that question is pending before the single judge.
Where is the show cause?
My lords, page 1, my lords, of the memo that I have just filed. My lords.
There's the copies.
Is this a show cause under 129? It is not.
No, no,
130, my lords. 130.
that is what we are contesting.
He is entitled to contest the 130 proceedings by way of appeal under 107, my lords.
No,
Sorry.
And this is not, there is no challenge to this. There is absolutely no challenge to this pending before your lordships.
no, this way of filing the,
It is not before their lordships.
not before this court.
That issue need to be looked into by the learner single judge.
Yes, yes.
Very well, my lords. But given the perishable nature of the goods,
We can only say this, let there be a 50% of the total goods.
may I request 100% my lord, by way of bank guarantee?
Lordship, the value of goods itself is 11 lakhs. You know.
Yes, that's what they are.
That is the total value of the entire.
11 lakh of.
No, but in so far as the remaining consignment, your lordship, out of 11
All right,
lakh.
please, is subject to everything. It's not that you are out of pocket.
Correct,
but
your
I am
lordship,
being-
but the value
How
of
would you
the,
justify 4 lakhs?
no, insofar as the contravention is concerned, your lordship, only the value worth 1,10,000 only is, there is a contravention.
How would you secure them? Tell us, if ultimately you don't succeed. How would you secure them?
Your lordship,
See, that's the purpose of an interim protection. And we don't want, it should be an onerous where you will be out of pocket of the complete amount and ultimately you succeed.
but in
We
any
don't want
case, your
such
lordship, they
situation.
cannot confirm the demand for the entire consignment which is available, seized.
So
It's-
that's the reason we are saying so. It's all right. I don't think we should really take it further. He will make it the total amount 5.5 lakhs. And subject to that, yes, really.
My lords, may I submit?
Get 50% of 11.
Please.
There is no, you are not disputing 11 lakhs is the total consignment.
Yes.
I am, my lord,
Yes.
because the stage has changed. If your lordships kindly see page 65 of the memo that I have just filed.
Say 16, huh?
65.
See, you must ask, you can seek the early disposal of the writ petition.
Very well, lords. My only difficulty is the perishable nature. I'm in your lordship's hands so far as the question of law is concerned,
We appreciate that.
my lords.
Once the goods are released, surely even if he doesn't succeed, how would you recover whatever is there? See that in any case, in normal course also, once you have issued a notice and he had not come to the court
My
and
lords.
you have confiscated the goods, very well.
My lords.
But in any case, for recovery, you will have your own procedure.
Yes.
My lords, what
procedure,
happens is that-
contemplated.
My lords, what happens is that when there is a fine, my lords, kindly see, if I may request.
It's all right. I think let's not take it. We'll say so 5.5 lakhs.
Because, no, my lords, if I may beg your lordships, if your lordships are directing deposit of 5.5 lakhs, let there be a bank guarantee submitted for the remaining amount of about 17 lakhs. That's the submission, my lords. 4 lakhs if he deposits already, if there is a further deposit, let there be a bank guarantee for the final amount. I'm in your lordship's hands as to the proportion. But let the amount under page 65 be secured, my lords. Because what happens, my lord, is under section 130, there is no provisional release of goods. The option is given to him the title passes to me, I'm entitled to auction it. There is no stay on my proceedings. I'm entitled to auction it. The option is given to him to secure the entire amount of the fine and take the goods. This order, my lord, defeats that. It is in that sense contrary to statute, and Supreme Court in the judgment in Kepan versus State of Uttar Pradesh says that orders contrary to statute, in fact, in that case said can be ignored by revenue. A slightly, my lord's sweeping order, but my lords, I would only request that if your lordships take the
65 is 22 lakhs.
22 lakhs. I leave it to your lordships. If it is 11
we-
lakhs
then
deposit,
we
11
can-
lakhs bank guarantee, I'm in a lordship's hands.
Then we can say this subject to what you take instructions.
Please.
Whatever 4 lakhs, you will pay them. Rest balance, give a bank guarantee.
My lords.
You're not out of pocket, bank guarantee in any case would be there. That will at least take inure to the benefit of both the parties, whichever party succeeds. And if they succeed, they will invoke bank guarantee. If you don't succeed, you will take it back.
Yes, your lordship, but only.
Take
difficulty-
instructions, we'll just pass over.
Please, your lordship, but only difficulty is he is a small trader, your lordship. And
See, that we are not going to accept. Small trader, big trader, if there is a liability which is standing against you, surely you have to
lordship,
fulfill it.
but
We are now balancing the equities. You would be not out of pocket. You'll furnish a bank guarantee,
for the value of the goods, I'm ready to furnish, your lordship.
not all the way. Now, don't change your submissions.
No, your
What we-
lordship.
1 minute, please.
Please,
Liability is 22 lakhs
that is,
on a demurrer.
no, on the entire goods, your lord, entire consignment, even though we are having a sufficient
Let's assume for the
document.
moment your writ petition is dismissed. What is your liability? It will be 22 lakhs.
No, your lordship,
Why?
I will be challenging the,
So you will challenge that? You will challenge that? That
That
will
is-
be worked out? You may say it may not be.
no, your lordship,
On-
I will be challenging this order also. Because your lordship, they have now quantified the demand on the entire consignment which they have seized.
We don't know
Even
where
though-
liability stands 22 lakhs. That is what you have challenged.
In fact,
No, your lordship,
he's not challenged that.
we have challenged the very initiation of proceedings directly under section 130.
Very well.
Apart from non-compliance of the provisions of section 129. your lordship.
That can be heard by the single judge.
This order has come after the learned judge has passed the interim order.
Yes, my lord. Because there was no stay.
But I don't, do you think that you want to pursue the writ petition or challenge this very quantification on all grounds, including the ground of 129?
I'm going to amend the writ petition itself, your lordship.
That's up to him, my lords.
Yes,
Now you tell us, you want to take instructions? We'll pass over.
no, my only respectful submission is that, your lordship.
We have heard you, we have also conveyed ourselves. You would not be out of pocket. Amount would be secured. Okay? Amount would be secured. Now tell us one thing, when that interim order was passed, this 22 lakhs figure was not there before the learned single judge.
Was not there.
It was there, your lordship.
My lords, it
Just before passing of the interim order, your lordship, this was placed. on
was
the
there.
day.
I stand corrected.
Was
lords.
placed.
Yes, your lordship,
The-
by the respondent. It was not served on us, but it was,
This was considered
yes,
by the
yes,
learned single
yes,
judge.
your lordship.
My lords,
It was considered.
on page 23, my lords, on page 23 of the memo, what I proposed to impose was the same amount. So it was there by way of a show cause notice. The final order has come, my lord, and there was no stay granted by
We
the.
are only putting, was it there before the learned single judge?
Yes.
Yes, my lord. The notice was there.
Yes.
Notice was there.
Not
even the
notice
order
was
was
there, even the final order was there.
Yes, your lordship.
The order was there. I stand corrected. my lord.
Was there.
I stand corrected. The order was also there.
Still the learned single judge say 4 lakhs.
Yes,
lord.
yes, your lordship.
My lords, and therefore, my lord, and he leaves the question of the interplay between 129 and 130 open. Therefore, my lords, 130, once the issue is there is no provision at all for a provisional release.
It's all right. See, we are on a 226 jurisdiction.
I understand, my lord.
That's not, maybe ultimately you can argue this surely when it comes to disposal. But we are in that, when the matter is pending 226 to balance the equity as an interim measure, this has been said.
But the only difficulty is, my lord, twofold. One, the statute contemplates an elaborate mechanism.
say the number value because of confiscation, it could be high. Why not we say this total value, what according to him, the total value is 11. Very well, the learner single judge, despite noting the fact that 22 still confined it to 4 lakhs.
Yes.
That's right. He will deposit 4 lakhs, the balance 7 lakhs, he'll give a bank guarantee for the extra amount between 11 lakhs and 22 lakhs. That I think we should not say anything. At
Let him
least to
execute a
that-
personal bond.
To that extent, he will be securing you.
Please, your lordship.
He's right, ready. If he
Well,
wants to give a personal bond insofar as the balance amount is concerned between 11 and 22, would be go a personal bond.
Yes, your
He
lordship.
will give that.
Yes,
My lords,
that is not. an
the,
issue.
so far as the order 130 is concerned, there are specific allegations of recycling of goods, bogus traders.
These are on this. We are not looking at it. Today, the challenge is only on an interim order. You
Please.
say 4 lakhs is too less an amount to secure it.
I would request something substantial, my lord, by way of bank
It
guarantee.
is substantial you require. Between 4 and 7, he'll give a bank, 4 and 11, he'll
11.
give a bank guarantee. Above 11 to 22, he'll give a personal bond.
My lords,
What else you want?
my lords. I'm in your lordship sense.
That's right.
I'm in your lordship.
Dispose it off.
Yes, your lordship.
Say this.
Only one point I would like to bring it to your lordship. There is a division bench of this honorable court, your lordship, already considering the provisions of section 129 and 130, holding that they cannot bypass the provisions.
Pre-amendment, my lords.
That's before the learner single judge. We say nothing.
Please, please. Your lordship.
The challenge in this appeal, with the consent of the counsel for the parties, the appeal has been taken up for final hearing, has been heard finally. The challenge in this appeal is to an order dated order dated 9th August 2024, passed by the learned single judge as an interim measure by stating in paragraph 6 as under. The submission of the learned counsel for the appellant states that as against a liability of rupees
22 lakh 35,000.
2,235,932 fastened by the appellants on the respondent, comma, the learned single judge has only directed for the release of the goods on deposit of amount of 4 lakhs with the appellants, full stop. According to him, if the appellants succeed in the appeal, before the learned single judge, and the liability against the respondent is upheld, comma, it would be very difficult for the appellant to recover the liability amount, full stop. On the other hand, the learned counsel appearing for the respondent would contest the liability as fastened above, as fastened by the appellants herein on the respondent. According to him, the total goods value is how much? 11?
11 lakhs, your lordship, around,
Is a round figure?
not round figure, your lordship.
Is 11 so and so. 11 so and so. According to him, the case of the respondent before the learned single judge was that the impugned action which has been taken by the appellants is in violation of section 129 and 130 of the Karnataka Goods and Services Act 2017. Full stop. In any case, the liability which has been fastened upon the respondent could not have been done by the appellants. Full stop. During the course of hearing, just say that in noting the order passed by the learned single judge, and also the fact that if a liability of 22 so and so has been fastened on the respondent, and also the fact that according to the learned counsel for the respondent, that the total goods value is being, how much is that amount?
I'll
Just give that amount.
pay.
We deem it appropriate to dispose of the appeal by directing by upholding the order passed by the learned single judge, and additionally directing the respondent herein to furnish a bank guarantee for an amount of rupees. How much, in whose favor the bank guarantee?
My lords, the Joint Commissioner of Commercial Taxes, or the bank guarantee in favor of Joint Commissioner, Joint Commissioner Commercial Taxes, my lord.
Joint Commissioner Commercial Tax.
Vigilance.
commercial tax
Vigilance,
vigilance,
my lords,
vigilance for an amount of, you have to tell us the figure.
my lords.
What is the lemon amount? How much is the figure? The goods total value?
13
My lords, on, I,
Lakh 83,350.
my lords, on page 65, the
11 lakhs?
12 lakhs, my lords, if your lordships take page 65,
Yes.
there is an amount of 13 lakhs 19,807, which is the penalty and the fine on the goods,
See, we want to know what is the total goods value.
my lords.
12 lakh 83,354.
12 lakhs,
53,000.
how much?
12 lakh 83,000. 354.
He shall give a bank guarantee for an amount of 5 lakh, no, 8 lakhs. 8 lakhs, 83,354. And which bond you call it?
Personal bond, my lord.
Personal bond. Who would give the personal bond?
The proprietor of the
And
respondent, my lord.
so, and also the proprietor being, what is his name?
My lords, I think it's Anji Babu.
Anji Babu.
Anji Babu.
Anji Babu.
Chekka Anji Babu.
Chikka Anji Babu. Chikka Anji Babu, is there any personal bond contemplated under the Services Act?
My lord, what has happened is that in some cases, the Supreme Court has directed it. Is there a form for the personal bond?
In terms of the format, if you have any format,
There is, I'll supply one, my lords.
you sure you have one?
My lords, there is no format under the statute. In some cases, the Supreme Court has been directed personally.
Right, give that format to him.
I'll give it.
In terms of the format. In terms of the format to be furnished by the appellants to Mr. Chikka Babu within how much time?
By tomorrow, my lords.
Within 2 days within 2 days. And on furnishing the bank guarantee and the and on deposit of the amount of 4 lakhs.
That has already been deposited. 4 lakhs has already been deposited.
Deposited?
Yes, sir. Long back.
On furnishing the bank guarantee and the personal bond within 2 days thereafter, the goods shall be released in terms of the directions given by the learners' union. The appeal is disposed of.
My lords. Your lordships may have to condone delay, my lord, because the intra-court appeal 30 days.
They just delay condone for the reasons stated in you have filed an affidavit?
Affidavit is filed.
Disposed. Next.
Serial number
I'm
2.
obliged.
Serial number 2, Shri Vikar Ahmad.
I appear for the appellant in the matter, no? I appear for the appellant. Lord, what has happened is this appeal has been filed against the rejection of a Section 8 arbitration application, my lord. There were 2 defendants.
Which page is the order?
On which the order was final
Yeah.
page number 22, my lord. The whole
Yes.
dispute was a money recovery suit for a sum of 8 crores. Now, in that, the breakup,
The suit is pending.
the suit is pending, my lord.
So now what has it done? He's dismissed the application.
He has dismissed my application, my lord.
Yes.
The reasoning given by him is that there are serious allegations of fraud, which is not arbitrable, is the reasoning given by the lower court. Now, that your honor would find at para 20, that because of allegations of fraud, he has not gone ahead and allowed my application. So I prefer this appeal. Now, what has happened is pending the appeal being filed, appellant number 2 has passed away, owing to which this court had directed to take steps towards the legal heirs.
See, if it is serious allegations of fraud,
There are not, my lord. That is my aspect. The entire dispute is,
just only a usage of the word fraud,
that's it, my lord. That is even,
substantial.
no,
Any criminal proceedings initiated?
they had filed a PCR, which also came to be dismissed, saying there's nothing.
Pardon?
They had filed a private complaint report. They had filed a criminal case. The criminal complaint too was dismissed. Even that auto copy has been filed along with this present appeal, my lord.
What is the
Your Honor.
relationship? What was the contract between the parties?
It was for supply of goods. Basically, the plaintiffs below the lower court had placed certain orders with different number 4 and 5, the supply of goods. Now, this was from 2014 to 17. In 2018, they came to the court and asked for 8 crores on 3 grounds. Instead of laptops, you have provided us tablets, you have not given the warranty, and some goods have not been delivered. These are the 3 grounds, my lord, as per their plaint itself. Now, all of these orders were placed in terms of purchase orders. This purchase order contained the arbitration clause. That's the only grievance, that this is amount.
What is the stage of this proceeding suit?
After the demise of defendant number 5, the appellant do, the past few years, it has been for taking the, bringing the legal heirs on record, which has not happened. Now it's posted on Friday for hearing, my lord.
What are otherwise the proceedings? What is the stage? Issues frame?
No frame, my lord. After
Pleadings?
the 2021, defendant number 5 passed away. Then the 2021, my lord. Then the court had issued directions to the plaintiff to bring the legal heirs on record. Just last week, the legal heirs also have been placed ex parte because they could not be served. And the matter is coming up on Friday for the purpose of hearing, my lord, wherein
Who had expired?
defendant number 5, my lord, who's also appellant number 2, as well as in 2021, my lord. Now the difficulty is this, my lord. The reason given the low court is on fraud aspect. Whether it's substantial or not has to go into. Matter is coming on Friday. As far as the appeal is concerned, against appeal number 2, appeal could be appealated. But my difficulty is now the matter will go on.
My lord says against.
Who had passed, just one, who had passed away?
Defendant number 5, which is appellant number 2, my lord, Mr. Venugopal Reddy. Venugopal Reddy, my lord. Yes, defendant number 5, who is also appellant number 2.
But the appeal is by only two persons,
Yes, my
two
lord.
entities.
Appellant number 2. Appellant number 1 is defendant number 4.
But why rest have not come?
Before, my lord.
If in the suit, you say defendant number 5.
Yes,
So
my
there
lord.
were 5 defendants.
There are 5 defendants, my lord.
Now, this
I-
order
Yes, my lord.
is against all the 5.
The purchase orders is only against defendant 4 and 5. 1, 2,
Acha,
3,
only 4 and
only
5.
4 and 5, my lord. That is the reason. The purchase orders were placed only against defendant number 4 and 5.
What is the claim against 1, 2, 3 then?
Yes, my lord. So the claim is that defendant number 2 and 3 are partners of defendant number 4 firm. And defendant number 1 was an employee with the plaintiff. And the allegation is that you have selected 4 and 5 who have provided products which are not to our satisfaction. Hence, they have made them also party. That is also one of the reasoning given by the lower court.
Your section 8 is not qua 1, 2, 3.
No, my lord. Only in 4 and 5, my lord. Only against 4 and 5, my section 8, my lord. The reasoning given the lower court is
2 and 3 are also the partners of 4.
they are not.
How can you segregate all this?
No, the thing is because the firm's name was what the purchase orders were placed on. Hence, on the name of the firm is how we had filed the application, my lord. Be that as it may, my lord, there are 2 submissions I wish to make at this stage.
My
Appellant
lord,
number 2
sir.
has passed away.
Just, we'll come back.
Appellant number 2 has passed away, who is defendant number 5 itself. Hence, as against him, I could not find the legal is, it stands applicated. Now the matter is coming on Friday. The legal is, they have been trying for the past 3 years, could not serve them. Finally, the court has placed them ex parte itself. The matter is set for trial itself. The entire basis of lower court order is 2 reasoning. One is serious allegations of fraud, and first is defend 1, 2, 3, as my lord has pointed out, are not parties to the purchase order, my lord. However, my entire argument before that was that allegations of fraud are only so as to not refer to arbitration. The entire dispute is money recovery on the basis of purchase orders. These purchase orders have an arbitration clause, and you for arbitration. And also the fact that the 1, 2, 3, the allegations made as against in the plaintiff itself is that you have acted in collusion with them. Through and under them is my submission is what I had made before the
You
law.
file your written statement.
My lord, defend number 2 and 3 had filed written statement. Defend number 1 has been placed ex parte. And
What about this appellant 1?
appellant 1 has filed his, he has filed it belatedly, my lord.
He has filed it.
He has filed it belatedly.
Then still then how can you pursue now
No,
arbitration?
no, my lord. As far as the section 8 is concerned, was filed first, my lord. The written statement was not filed. After the application was.
What we are asking you, have you filed it thereafter?
Thereafter, my lord.
On merit also?
My lord, as far as after the rejection is concerned, since the 120 days time period is there, application that has filed for the purpose of
Was
ensuring
it
that.
within
my-
120 days?
No, my lord, there's also delay in that. So
How much?
a few months, my lord.
On the law is settled,
Yes, my lord.
would you stand there?
That is where my.
You must take into consideration all these aspects. Would you like
my
to?
lord. That is where my difficulty is because in fact, the law goes on to say that you came to the court, file wakalatnama and you file application for extension of time to file written statement. Then you file section 8. Hence there's a delay and a law not law.
Law, no, that law is settled.
Yes, my lord,
So
but
you
that
have
is the.
taken a risk.
Yes, my
You have
lord.
taken a risk.
Now here, the difficulty is that I'm left with no other option. My section 8 is rejected, where I still believe that these allegations are merely to ensure there's no
Your
arbitration.
section 8 rejected, your written statement would be rejected.
Absolutely not. That is, I have nowhere to go. And I am only related to defend number 1.
Let's see what are the allegations of fraud.
Yes, my lord. May I request my lord to go to the plaintiff?
My lords, may I make a
Ah,
request?
yes, sorry. Yes.
My lords, on the merits of the matter, I request for this matter to be taken up at least
Yes,
tomorrow.
we are understanding the matter, that's all.
A
Le-
PCR was filed against the appellant number 2, my lords, which came to be dismissed, and a revision petition has been filed against the same, my lords.
Which order?
My lords, alleging fraud, my lords, we had filed a complaint against the appellants, my lords, it came to be dismissed, the PCR, and against which we filed a revision petition, the details of which I'll produce before.
Who alleged fraud?
My lords, I'm
You have
the,
alleged fraud.
please, my lords, I have alleged fraud. I'm the plaintiff before the trial court, my lords. And on that ground, their Section 8 application came to be rejected. There are other grounds as well, my lords. On merits, I request for this matter to be taken up on.
And how would you contest minus fraud? How would you contest Section 8 then?
My lords, all the defendants in collusion with each other have defrauded me, my lords, and my purchase order is only against the defendant number 4. That is the appellant number 1 here in, my lords. On merits, I request for a date to be
Yeah,
fixed,
we'll
my
just-
lords.
What is the finding of
Yes,
the
my lord.
learned
Can we
judge?
take page 67, my lord? This is the order passed by the magistrate court, my lord. Page
This
67.
Ayesami and Amit Lalchan Shah,
All have been referred to before the lower court, my lord.
yeah.
They produce those judgments as well. Page 67 is the order of the learned fourth additional chief metropolitan magistrate. May I request my lord to take para 10, my lord, at page 76. This is the finding, my lord, in the PCR file by them.
Where is the plaint?
Page 39, my lord. Page 39 is the plain file. Page 39, my lord.
Page 39, you are the plaintiff there.
No, I'm the defendant, my lord. This is the plain.
No. Atayati, what
That
is this?
I'm for Atyati, my lords.
She is the respondent number 1 before this court. She is the
Okay.
plaintiff. In that honor, kindly see, the crux of the matter is clearly spelled out.
Achaka,
in,
yeah.
Page number 49, my lord. Page number 49. It is evident as a result of this is where he alleges fraud committed by defendant number 1 in collusion defendant 25. The plaintiff company has suffered loss to the extent of 8,21,61,512. The defendants jointly and severally are bound and liable to the case of the plaintiff under the following heads. This is where the entire thing clears out, my lord. Rupees 2,65,71,250 being the cost of devices not delivered, even though the plaintiff has paid for the same. 52,34,562 being the difference for having taken payment from the plaintiff for supplying laptops and instead supplying tablets. 5,03,55,700 being the cost of the additional warranty charged to and collect from plate but not supplied. So this is the grievance of the plaintiff. He's asking for money on 3 heads. You have taken money and given laptops instead of tablets, tablets instead of laptops. You have not been additional warranty and you have not delivered these devices. Entire civil dispute. And all of these devices owe their genesis from purchase orders. You can kindly see the purchase order, a sample purchase order.
Okay, let the council come. We'll have it. Request for adjournment is made on behalf of the council appearing for the
Respondent number 1,
respondent number 1.
please, my lords.
Who are the other respondents?
Hello, respondent number,
What about 2, 3, 4?
the 2 and 3 are partners of appellant number 2, my lord.
Pardon? No, are they, you are representing them?
No, my lords. No, my lords. I appear only for the respondent number 1. I have
What about the notice to them?
We dispensed with, my lord, because end of the day, at my risk, I'll take it, because the entire dispute is between us and them on basis of purchase orders. They have been brought about it only to avoid arbitration is my argument, my lord. Notice to respondent number 2 to 4 to be dispensed with. And as far as the matter is concerned, the lower court is coming up on Friday, my lord, for hearing. I have also filed.
We don't mind deleting it. What would be the effect of deletion on your allegations?
If I were to succeed in this Section 8 application, then they become redundant. Because my entire defense is that they are not necessary parties to the entire dispute. I have supplied the goods, and your grievance is that I have not supplied this. I am the one answerable. If you are to establish that they have provided any service to you and you have taken or they have taken any money from you, then there will be a civil suit, my lord. At the end of the day, they have absolutely no grievance as against defendant number 1, 2, 3 as far as supply or services are concerned. The entire claim is as against purchase orders for which I have issued the devices. Appellant number 1 and 2.
My lords, if I may make a submission, the respondent number 2, 3, 4 are the family members of the appellant number 2, my lords, and the appellant number 2 is a partner.
They are
in,
related.
Yes, my lord.
They're related, my lords.
2 and
So hence I filed the suit against all of them, my lord.
family members. Now here the aspect is, let me clarify, my lord. Defendant number 2, respondent number 2,
Okay.
respondent number 3 were married.
You don't want to serve 2, 3, 4?
I'll issue notice, no difficulty. I'll take notice as against them. I'm
No,
just
we
saying that.
want, we know, you want or not? You want to deletion, we'll record it.
Appeal number 2 is passed away. The appeal has been, appeal number 2 be taken. For 2, 3, 4, I'll take notice, my lord. End of the day, if bringing them on the
Says,
court, they'll get
very
back.
well. The learner, just say that learner counsel for the appellant at the outset submits that the appellant number 2 has expired
Expired, no.
and the appeal qua the said deceased appellant stands abated.
Yes, yes, yes.
So the submission is taken on record. We find respondents 2, 3, 4 have not been served. Let fresh notice be issued for service on respondents 2 through 4.
Yes,
Returnable on. So they are family members.
Family members, my lord. They divorced direct, my lord. At the point of the conviction, they got divorced. At that point in time, they were.
They will just give it.
16-12.
Yes, next.
Nearly for submission, my lord. Matter is coming up on Friday, my lord. So far, it has been not going up because of the
We
demise.
say nothing.
My request
We
for-
say nothing.
Reason I'm saying.
We will hear it and then decide.
Very well. Then
Whatever
my
is the
request for
course,
urgent-
see, even if this trial court is going on, let it go. And if
my-
ultimately we agree with you, we'll set to not everything.
But then I'm in the situation wherein my section 8 has been dismissed. My written statement not filed with 120 days. I'm in a situation. I'm like.
Is there any order passed by the trial court on your written statement?
Yes, my lord. They have-
Has been taken off the record?
I mean, I filed application for that aspect. That's why,
And this appeal has come after that order?
no, my lord.
Before that?
Yes, my lord.
Then we take it. Next,
Could have-
Serial
earlier be given considering the-
nothing doing. You will serve them, please.
Serial number 3, Sri Vivekananda.
Claim for appellant. Like this, each time to take steps in respect of point number 1, 3 and 4.
Ma'am, item 3. no?
Item 3, sir.
What do you say? You have to?
I have to take steps in respect of point number 1, 3 and 4. my lord. Thank you.
1, 3 and 4. Yes. Just say that let fresh notice be. What is the report, ma'am? We find that respondent number 1, 3 and 4 are still unserved. The registry, the report of the registry suggests the following. R1 addressee left, R3 no such person, R4 addressee left. On the appellant furnishing fresh address of the respondent 1, 3 and 4, notice shall be issued to the said respondents returnable on.
17-12. Serial number 4, Srimati Vanita. Serial number 4,
Who appeared for R3? Deputy Commissioner, you appear?
I appear. This is an application to recall the order, the dismissal. My lord says, nobody appears even today, my lords, the matter appears to have been going on since 2017 without any substantive record in the order sheet of the matter having been conducted.
Since it has been filed against dead person, no steps taken. It was dismissed for.
When was this application filed?
2000.
What is the last order, ma'am?
this is the dismissal.
That's the last order. This application was never listed in the court.
No, my lords, the recall application appears to have come up for the first time.
Just say this IA 1 of 24, this is an application seeking recall of order dated 31/7/2024. We find there is no representation for the applicant in the interest of justice, re-notify. We'll see on the next date.
Very well.
6-11. Serial number 5. Serial
Lord, I
number 5.
appellant in this case, my lord. My lord, in this appeal, I have challenged the orders passed by the commercial court in commercial AA 132 of 2021. My lord, there was a delay of 21 days to file this appeal because there was a lockdown at the time in April 2021.
Which appeal? Before the,
This current appeal, my lord, present appeal.
okay.
I have filed an IA, my lord, along with the affidavit.
What is the case on merits?
My lord, this is a tender given to the respondent for fixing up a railway overbridge near Dharmapuri railway station. And he should use the RCC concrete at the site. And the concrete should be mixed with the machine. So,
What happened? This is only an interim order.
please, my lord,
What happened to the work completed?
work completed.
What happened? Did you raise any disputes?
We received this, my lord,
Petition pending?
my lord, the contractor also agreed and we have deducted the payment extra made to him. And there was no dispute, my lord.
They have
no.
deducted.
Deducted, my lord.
And what about the future bills?
All future bills also we are not paid, my lord.
On the basis of that, then what remains in this?
Nothing remains, my lord. That's why I want to
Then
submit.
why don't you withdraw this?
And my lord, as per the order passed by the learned judge also, my lord. It is only for a period of 90 days valid, my lord, this order was. The impugned order was valid for 90 days,
In terms of section 9.
please, my lord. So it has become infructuous also, my lord.
So what do you say? You want to withdraw this?
Please, my lord, I'll file a memo, my lord.
You want to file memo?
Please,
File memo. At the request,
sir, in the course of the day, I'll file a memo.
we will just simply re-notify it,
Please,
file a memo,
please,
let it come on record.
please,
Then we will allow you to.
please, my lord.
At the request of the counsel for the appellant, when do you want? Day after tomorrow?
Day after tomorrow.
Day after.
5510. Serial number 6. Sundar Raman.
My lord, I appear for the appellant in this matter.
Yes, ma'am.
My lord, this is a commercial appeal that has been filed challenging the judgment of the commercial court in dismissing a section 34 petition. Today, my lord, the matter has been listed on hearing on two applications. One is 2 of 24 and the other is 3 of 24.
You have filed the application for withdrawal of bank guarantee. Who?
I have. No,
Bank guarantee.
Withdrawal there.
Withdrawal of bank guarantee. I
Filed for
have
the
filed it.
withdrawal of the money. Now, the bank guarantee is on the strength of the earlier order. Are we right?
Please, my lord,
There
I'll
was an
just,
earlier order passed
yes,
for the deposit of a lesser amount.
please, my lord, there was an
And the
order
bank
to
guarantee
say,
for the balance something.
please, there was an order that was passed on 19/1/2024, which directed us to deposit the decretal amount along with the interest in the ratio of 50% bank guarantee, 50% in cash. What we
Now, the cumulative would be the complete amount
cumulative
which
would be the principal along with the interest accrued up to that date, my lord,
on the complete amount.
on the complete amount.
Oh.
That added up to almost 1 crore 2 lakhs and odd, my lord. Thereafter, on 7/2, we filed an application seeking modification to say instead of depositing it in the ratio of 50%, we will deposit the principal amount of 55 lakhs, which is higher than the 50% ratio, and the remaining by way of a bank guarantee. My lord, that application did not come up for consideration. Therefore, we went ahead and deposited the principal amount on 26/2 and the bank guarantee on 27/4
In terms of the first order.
in terms of the first order. Thereafter, on 5/7, our application for modification came up for hearing. On that date, noting that there was some amount of delay in our actual action in depositing, the court modified
Said
the
now
order
you
to say
complete.
100%. In view of that order of 5/7, my lord, we're seeking to withdraw the bank guarantee that we had filed, where we will extract the money from the bank and deposit 100% cash, which has been ordered by this court, because there is a cash flow issue with the company. So if we're able to withdraw the bank guarantee and release the amount that we've deposited with the bank, we'll be able
No
to
objection.
deposit. We had actually complied, my lord. There was a delay of a
So
few
better
days.
would be, let that earlier order of 50% and bank guarantee remains.
If the other side has no
Secured.
objection.
I have only one submission, members. What? Insofar as the entire amount is concerned, members, they filed an application pursuant to that. I filed even on that day when they sought for modification, I said no objection. On that day also when it came up.
See, then appropriate shall be, you will comply with the second order,
Please.
then withdraw your bank guarantee for which he will consent also.
My lords, that's what they are saying is that
Only
I am not able to comply. I am
Right, we have understood. That's what we are conveying.
Cash flow
See,
issue
your
with the
apprehension is, once bank guarantee is out, to the extent of that 50% of that bank guarantee amount is not secured.
no, my lords. What I am requesting, my lords, is that if they are ready, they are saying that they are ready to deposit 100% before this court. That is what their application is.
Yes.
She's saying, but subject to
I have no objection.
guarantee be released by the court,
I have no objection.
enable them to encash their bank guarantee and their
Deposit.
deposit.
Because I have no objection to that. I have no objection to that. My lords, and also my request is that
Then let the money come first. Then only we can consider your application.
Yes, yes.
Yes.
My lord, the only difficulty is because of the cash flow issue in the company.
So he's
because we have-
agreeing for that.
He has agreed, my lord. The reason is we have gone to another bank because the specific order was through a nationalized bank. And since we do not hold
That's
such
right.
an account, we have deposited monies there to ensure we have necessary balance for this bank guarantee. Our only request is the moment we withdraw this, the money will become available and we will deposit it before the court in the time frame stipulated by this court. That is the only difficulty the company is facing.
Where do you say in your application?
If I can request my lords to.
This is IA number.
This is I number 2 of 24, my lord. It was filed on 18th of July, 2024. My lord, in my affidavit, I have not stated so that the company is facing these difficulties. We have only simpliciter sought withdrawal of the bank guarantee.
See, that's the point. There should be file an affidavit.
I will file an
After withdrawing,
affidavit
we
that-
want to take your stand on record.
My lord, that's there at para 5.
Where do we get that?
Para 5, my lords, were to see, this withdrawal will also allow the appellant to return the bank guarantee. to the
You
bank.
have said so.
We have said only,
That's-
no, my lord, we have not spoken about the difficulty that the company is facing in
Forget,
terms
we are
of
not
cash.
on
flow.
difficulty. We
I
are on
was
the,
under the impression that is what the court was, but we
we
have
are on the
stated,
last line in turn, allowing them to
Yes.
deposit the money.
we have stated this.
Just say this, we will only, and which is your IA for
My
withdrawal?
lords, IA 3 of 24 minutes. IA 3.
Then 3 of 24 is here
Yes.
on record. Just say this IA 2 of 24 has been filed by the appellant herein
Please.
with the following prayers. Full stop. Suffice to state that on 7/2/24. What was the earlier order?
The
first
earlier order was on 19/1/2024.
19/1 here. On 19/1/2024.
My lord, if I may be permitted to make one more submission. The 19/1 order, as my lords rightly pointed out, required us to deposit the cash as well as a bank guarantee. My learned friend has filed an application seeking withdrawal of that amount. If I can request us to continue with that order and post a date for hearing, the matter may be finally disposed as opposed to us again furnishing further monies. They can withdraw what we have already deposited subject to them furnishing a bank guarantee, and the matter may be disposed, because again, for us to submit this, withdraw the money and furnish it and then go ahead would again delay the matter. They can withdraw what
Are
we,
you saying the complete amount has been secured?
the complete amount as on the date of 19/1 has been secured. As on date of us depositing, that has been secured. We have paid 55 lakhs in cash and we've paid 47 lakhs in odd in bank guarantee. If my lords can permit us to continue with that order, they can withdraw the 55 lakhs that we have deposited. Matter may be fixed for hearing and
You
we can
say-
dispose it.
I'll need because my instructions were to insist for 1 point. But I see the fairness of what is coming from the court.
She's saying is rather than then she will not even press her application for taking the bank guarantee back.
Please.
That has come about because of the second order. Take instructions to the extent of 55, which is deposited, not in the nature of a bank guarantee, obviously. You will withdraw that.
Yes, ma'am.
And bank guarantee will continue here,
Please,
continue to be, extended also.
please, my lord, it will be.
And then if your instructions are in the affirmative, then you will file an affidavit stating that this is what has been deposited on the strength of earlier order. Second order, they have not done anything on the basis of second order. And you are ready to withdraw that amount. Okay. The host, your prayer is for the complete amount. Do that. Just cut it. The learner counsel will record your submission. The learner
Yes.
counsel for the appellant states that though the appellant has filed the IA 2 of 24 with the following prayers, comma, if the respondents with the following prayers, she submits that she will not press the present IA if the respondent counsel, who has also filed an application for withdrawal of the complete amount to be deposited in terms of the order passed by this court, which is the second order,
Well, the second order was passed on 5/7/2024.
5/7/2024. The respondent is agreeable to withdraw the amount of how much you deposited on the strength of first?
55 lakhs,
18,496.
55 lakhs, 18,000.
496.
496 deposited by the appellant in terms of the first order, that is 19/1/2024. And continue, so that the bank guarantee furnished continues to be, the validity thereof continues till the disposal of the
Please.
appeal.
There's only one difficulty which my lords have to address, which is that there's a direction to the appellant to furnish the full amount. That order my lords would have to modify. That means the previous IA my lords would have to consider and pass on.
We will, you're right. That's the reason we are saying if your consent is there, this is only to take your instructions if your consent is there. See, ultimately, the order has been passed for the benefit of yours. It's your to secure your amount, what you have received. Or we don't record anything, we will just re-notify it for you.
No, my lords, what my lords have recorded is fine. And I'll file an affidavit in the manner in which my lord, because then the order will become, then it will become complete. That means I am agreeable for modification of the
That's
order.
right, we are saying.
My lords, I follow. I'll file an affidavit to that effect.
We are still open. You don't want to take the, we will ask them to deposit the complete amount.
I'll get instructions.
Even if you still want, no, it should be complete amount in terms of the second order, we will ask them.
Because IA was.
This is only being passed because of the consent being given.
My lord, they have agreed to seek instructions, my lord, so we can.
I'll get
Pardon?
They've agreed to seek instructions on modification of the order. I would request that we,
No, then we'll continue with this order.
please.
Yes.
What did we say last? Disposal of the appeal. At this stage, learner counsel for the respondent seeks time to take instructions.
Week's time.
How much time?
Week's time, max.
Week's time, after 1
My
week.
lord, a date may be fixed, my lord.
Yeah, we'll fix a date.
Please,
12/11.
please.
Okay, thank you.
Serial number 7.
For the respondent. On the other day, my lord, we tried to settle the matter. But my client is prepared to pay the principal amount of 25 lakhs. And they are at 30 and plus.
Well, in the month of October 2023, well, the counsel for the appellant in the presence of the appellant offered 30 lakhs. Well, the respondent said that is too low because this amount is given in the year 2006. He was asked to improve the offer made of 30 lakhs. Now today he wants to come down to 25 lakhs.
Because of
Not
his age and
What are you agreeable to?
Well, if he gives me
he told me for 35 lakhs, if
So what
I
is
told
your-
him that 35 lakhs, I will ask the respondent to agree. I have told him in the morning.
What are your instructions?
my lord, he's not able to pay because of his age.
Very well, then we will proceed with this. What do you say? If it's not agreeable, then it's not agreeable to both of you will proceed. Okay, what is the issue now? Let's.
My lord, this is arising out of a service agreement. According to the claimants, my lord,
Okay,
they have the appellant herein failed to adhere to the.
pass over. Yes, pass
Not-
over.
Yes.
Pass over.
Please.
Just pass over, ma'am. Next.
Serial number 8. Shri Sangamesh.
Yes,
This is arising out of arbitration proceedings, my lords, where the arbitration proceedings, my lords, there is a direction to pay, my lords, the amount paid by them, paid by the claimant, my lords, refund of 13 lakhs along with interest. In fact, we tried for a settlement, but there was no settlement. And The amount received, my lords, there is no dispute as such.
Who appears for the?
My lord, I represent the first respondent.
You are the contesting respondent?
Yes, my lord.
Yes.
My lord, they have, my lord, in execution proceedings, my instructions are they have paid about 9.5 lakhs.
How much is the balance?
My lord, I'll furnish the calculation, my lord.
How much is the liability?
Lords, it is 13 lakhs 10,000 along with interest, my lords. The
But
interest
now
has-
what according to him is in execution around 9.5 lakhs paid. Are we right in saying, hearing that they have paid 9.5 lakhs? You don't have
Yes.
any instructions.
Lords, I do not
My
have
lord.
any instructions regarding it.
How much is the balance then?
My lord, may I seek for a short accommodation, my lord? I'll ascertain my lord, what is the amount paid.
No, we can do one thing. We can just pass over, get your figures. And
Please.
how much is the total liability? And possibly you can also ascertain it. This has been paid. How much is the liability and what are his views on this? Take instructions.
It can be on Monday, my lords, because I have to contact the client.
Just say that at the joint request of counsel for the parties to take instructions, re-notify on next week.
Sir,
November.
511.
Not 511, ma'am. Just give thereafter 1 or 2 days.
1311.
30. I'm
Please.
obliged.
Please.
Serial number 9 is Swarup Anand. Serial number 9.
Accommodation, my lord, there's some inconvenience. Short accommodation, next week, anything.
See who appears for the other side.
Mr. Swarup
Swarup Anand.
is heard by for law,
Oh, have
before
you
other
informed-
bench.
Have you informed him?
He was here only, my lord.
Request for adjournment is made on behalf of Mr. Madhukar Deshpande.
Yes.
Okay, which request is not opposed? He's seeking adjournment in this,
Yes.
which is not opposed, re-note. All these appeals,
Yes.
20th of November.
they arise from the same common order.
Same.
No, my lord, there are different orders. In fact, they arise out of the same schedule offense.
Yeah,
So the
the
principle-
foundational facts are.
Foundational facts are.
Foundational facts are the same. The other aspect is this, my lords, that the prime accused, who is the subject matter of the schedule offense, the schedule offense for him has been quashed.
It's been quashed.
It's been quashed as well as have been discharged in the section 45 complaint in the PMLA proceedings as well. So in these circumstances, my lords, it's a very narrow scope for determination.
You take instructions.
Yes.
Just give it.
If I could ask for a shorter date, my lord,
You just give your date.
20th November, sir.
anything earlier.
What else you want?
I'll leave it to.
Next.
Serial number 10, Shri Mithun.
We'll file the settlement report, short accommodation.
You filed this settlement?
We will file the settlement report.
When did you file it?
No, we will file it, my lords, a short accommodation.
Settle principally.
Yes, my lords, please.
When will you file it?
Short accommodation.
In both the matters?
Please, my lords.
1 week, 2 weeks, how much?
2 weeks, my lords.
2 weeks. Shall we record your submission? You have
Please,
settled it?
please.
I'm handicapped because I don't have the full paper. But it seems that they're entering into a compromise. So far, but I have not been told anything about this.
You appear for whom?
Happy for the first respondent. That's one, two.
No, but there are others also. No? 10.
Appearing in both the cases, Mr. Ramesh?
Please?
You're appearing in both the.
No, but I have wakalat only in one matter, 10383 of 18.
There is only one respondent here.
There's only one. For
The
that.
first respondent has passed away.
Who?
I mean, there are 2 respondents. I mean, one is,
No.
that is like one.
Only respondent
Yes,
in my
please.
matter. I'm appearing in that. He's there. He's not.
No, one, Mr. John Melvin Collin.
Colin.
Please, madam.
He's there. Very.
There was, but the cause list says H. Shetty. Umesh Shetty.
That was the arbitrator who was appointed, madam.
That's the arbitrator who was appointed. I don't think.
He was the arbitrator.
Arbitrator.
He has been deleted, it appears.
Yes,
Please,
yes.
my lords.
Okay. Now you appear for Mr. Collin?
Colin, yes.
No, very well. The learner counsel for the appellant submits. that the appellant has in principle settled the dispute with the respondent. Full stop. Mr. Ramesh, who appears for the respondent, and just say further, and he intends to file the settlement agreement. Full stop. Mr. Ramesh states, you have instructions on that?
I have not received any
Mr.
instructions.
Ramesh states that he shall also take instructions in that regard.
Yes.
Just lift after 2 weeks, man.
Obliged.
Please,
1411,
please.
serial number 11 adjourned. 12, serial number 12.
Yes.
Let in serial number 12 minutes.
Ma'am, just give us the file.
I mean, still number 12.
11 or 12.
And adjourned.
MFA.
Sir, 11 adjourns.
You are in 11. But there was a mentioning made in the morning. Were you not informed about the mentioning?
That confusion in the, that is a separate case number.
You appeared in the morning.
Yes, yes, that is pertaining to Tolu 65 or 23, you got confused. He made a wrong submission. Instead of Sandra serial number,
Was
our
it
serial
this
number is
court or
exact. Yes, yes, he got confused.
But both are here. You are the appellant? We
I
don't
appear
know
for respondent.
which matter he has mentioned.
Yes, he has mentioned Tolu 65 of 2023.
What is that number? Just check up, man.
He got confused.
1268 of 2017. That is serial
What is
number.
that number, serial number? 22.
1268.
You just call this council. Mr. Shiva Prakash had
You wanted to furnish some Kannada translation.
just call him, man. But he mentioned it. Then
Serial number 22, Shiva Prakash, SH Prashant.
okay, let's take 11.
Not for the appellant.
When they set together.
Just cut it, man. Don't put it. Yes.
One submission, subsequent to filing this appeal, respondent paid 22 lakhs 5,750 as return payment via SBI check.
22 lakhs.
5,750 via SBI check dated 27/6/2020.
You were the claimant there.
He was the claimant.
He was,
You were the claimant.
as retention
How
amount.
much is the total now liability?
Liability is mirrored 33 lakhs plus 2 lakhs, that is 35.
This
around
amount is
35
towards
lakhs.
retention amount. This amount what I have paid as per the retention amount, as per the order dated or passed in AS 109 of 2014 dated 20th September, February 2020.
Lord, the total retention amount claimed was around 26 lakhs 26,000. Out of that, my lord, the district court held, my lord, that I am entitled only for 24 lakhs and odd. Now that amount, my lord,
Is
after deducting the counterclaim amount claimed by them,
They have paid
they
subsequent.
have paid the balance amount. That has been admitted. But
It may be-
however, my lord, I have stated that subject to the outcome of this appeal, they may have to pay the balance.
How can the court do this kind of, how can pass such kind of an order? It's not permissible in law. Either you will set aside or retain upheld. But not in the case as if the court is substituting itself as an arbitrator. Modify to the extent, that's not permissible.
Yeah, satisfied, court order is satisfied.
You see page 54?
Order date, kindly look into the page number 75,
Pardon?
page number 75.
That is 55. 75.
And,
That's right. We have 75.
order.
Yeah, read it.
Order portion. Award in respect of claim 1 and A and B hereby set aside.
And the third one is award in respect of.
C3.
Award in respect of retention amount claimed under claim 2 is modified to the extent of admitted
That's-
amount of loans.
That could not have been done. Will uphold or set aside. There is no third. On, if anything, if it is upheld, if you have anything, you will work it out in terms of your contract.
Yes.
Reinitiate if permissible in law. This could not have been done.
In compliance with the second portion, you have paid this amount.
And you were the claimant on 2? This was your claim?
That was my claim.
Then what was the actual amount awarded to you?
Actual award was the 26 lakhs.
So now he has modified by 2 lakhs.
2 lakhs.
Are you still, are you challenging this
Yes, I am challenging.
to the extent of 2 lakhs?
2 lakhs.
Now, what about the claim number 1A and 1B?
That is, my lord, together, that is claim number 1A and B, that together comes to around 33 lakhs odd. My lord, that is being claimed here.
That is beyond contract.
That is, my lord, towards the balance amount of the final bill.
So, but you are serious to challenge this conclusion of the court. Otherwise, in law, it's not permissible.
Yes. My lord, I have taken grounds also.
Okay, let's see your claim on 1A, 1B. Were you ready to argue?
No,
We'll have it, we'll just pass over, we'll come back.
not for admission. If it is to be taken up for final hearing, my lord, a short accommodation will be. Next week, any date I'll
Okay.
complain.
Let's see the finding on 1A, 1B.
Yes. My lord, that is, my lord, in brief, I'll say the facts, my lord, to understand the judgment.
Pardon?
I may be, my lord, allowed to
Let's
say.
see on what ground he has set aside.
Yes, set aside, my lord, that as per class 14.8 of the agreement, my lord, anything which was not included in the final bill, my lord, is not permissible. So that was beyond the scope of the agreement. That is what, my lord, they filed an appeal before the district court. And, my lord, that was upheld by the judge. My contention, my lord, is that that was, my lord, elaborately discussed and granted by the arbitrator. Because I had claimed under 2 heads, one 27 lakhs and another 6 lakhs under 2 heads.
But was not part of the main bill.
Not part of the final bill.
No.
The final bill amount,
Beyond.
my lord, is around 18 lakhs, which was due to me. But I claimed, my lord, 27 lakhs plus 6 lakhs. That is, my lord, around 33 lakhs.
So what their claim is only 18, any dispute covering 18 lakhs only is payable.
Yes, payable.
Or even arbitrable.
Arbitrable.
Not nothing more, 9 lakhs are not arbitrable.
None. Then, my lord, the district judge.
But your final bill was not for 27 lakhs.
It was not for.
Then how would you answer this when the bill was for 18 lakhs? Why did you enhance it to 27 lakhs?
My lord, because the work, my lord, which was the total value of the work, my lord, was for 4 crores 44 lakhs and odd. That one, my lord, overshooted to 5 crores 98 lakhs. And, my lord, beyond that additional work was not allotted to me. But however, my lord, I continued as per the terms of the contract and completed the work. Towards the extra work done by me, my lord, I charged the amount on escalation. And on that basis, my lord, I calculated the amount, it came to 27 lakhs and another amount.
But why didn't you not include it in your final bill then?
My lord, that was done, my lord, at the time of filing the claim petition. It was definitely not included.
Is this clause reflected, this 14.8?
Yes, it is reflected, my lord, in the
Page?
Page number 51.
51. Cessation of, my lord, 51.
Para 30.
Para 30. Cessation of employer's liability. The employer shall not be liable to the contractor for any matter or thing arising out of the or in connection with the contract contract of execution of works unless the contractor shall have included in the claim in respect thereof in its final bill.
Further,
So both the claims, 1A and 1B based on 14.8.
14.8.
What
My
do you
lord,
say?
however, subsequently, my lord, we stated, my lord, that I am entitled for the balance amount. That balance amount, my lord, accrues on the basis of the final bill. If lordship sees, my lord, the final bill. The final bill was certified by the PMC, my lord, the project management consultant, for rupees 6 crore 29 lakhs. However, my lord, another person who was not named in the contract by name Nagesh Nayak, my lord, he recertified that to an amount of 6 crores 10 lakhs. There was a deficit of around 18 lakhs. That was to be paid, my lord, because he was, what happened was, my lord, the PMC, after certification of the final.
But 18 lakhs, you got it?
No, I have not got. My lord, judge, the honorable district judge says that, my lord, after abandoning of the PMC, my lord, before certification of the fifth bill, I consented for appointing of another person by name Nagesh Nayak, my lord, to certify the bill. My lord, therefore, when I agreed for the certification of the bill, then I cannot, I am now stopped from claiming, my lord, the balance amount also. That is what the finding is. And now nothing.
Balance is beyond 18 or?
It is beyond 18 and odd. My contention, my lord, is that the PMC is the, my lord, final authority to certify the bills. The final bill was certified by the PMC. What was agreed, my lord, when he abandoned, what was agreed by the claimant, my lord, was only the finalization of the bill.
But you can still argue what 18 lakhs has been denied to you?
Yeah, that I can have.
That you can argue.
Yes. I'll have.
That you can argue, not beyond that.
Yes.
No, but if we have understood you, is this even the 34 court rejected the complete claim itself?
Yes.
Not even considered 18.
It considers 18.
On merits.
On merits. And says, my lord, that it is not possible.
one submission. Initially, before the arbitrator, they have claimed under 11 headings. Arbitrator rejected all 9 headings on the ground that is beyond the contract. Any of the 14.8. All are rejected, except retention amount and this another amount. This number 1 is rejected by the court. Any of this clause number 14.8.
But suppose tell us one thing, 14.8 is on the arbitrability. 14.8, what are the claims which heard eventuality? Just say that the request of.
No, that is subsequently paid, they have accepted the amount.
Pardon?
This amount is 22 lakhs is, they have
24.
accepted it.
24.
24, I did a counterclaim amount, which is in my favor. Therefore, this balance amount is paid
The request of counsel. for
immediately after the
re-notify.
court order.
Submissions be filed by the counsel for the parties. It's now by annexing the judgments on which they intend to rely. Within 4 weeks list.
Records may be necessary, my lord.
Records.
TCR has come.
Yes.
Received. 312,
Obliged.
Next.
serial number 12. Serial number 12.
This matter, my lords, I appear on behalf of the appellant.
To the respondent to the matter, my lord.
My lord, the issue is this, my lord. The appellant.
Just show us the file. They have filed the wakalat? Yes.
My lord, the issue is only this, my lords. the arbitral tribunal, my lord, rejects all the claims, my lords, advanced by the claimant in the arbitration, who is the respondent before your lordship today. But my lords, on the basis of a claim that was not made, which was not pleaded, and in respect of which there was no evidence whatsoever, the arbitral tribunal has awarded a sum towards loss of profits. And my lords, that is the grievance in this matter, because my lords, the arbitral tribunal exceeded the scope of its reference. My lords, this is
Which are the judgments you are relying upon, Mr. Nair?
my lord, this is really,
You have to show the judgments.
Yes,
on
ma'am.
this. So it's a minus, without the evidence, loss of profit could not have been.
could not have been awarded.
But
But
in
we
law,
will-
whether they can presume so, at least some percentage of profit.
But that is what has been done, because my lords, the claims before the arbitrator was only in respect of outstanding invoices which were not paid. The tribunal says that there is no claim on the basis of those outstanding invoices. And that was the only claim that was made. My lords, the sum of rupees.
The claim was based on invoices.
Only on invoices. And all of those claims were rejected by the arbitral tribunal. After rejecting all those claims, the arbitral tribunal says, nevertheless, my lords, we have to award around 60 lakhs.
Let's see the finding.
My lords. My lords, I'll just take your lordships to, my lords, the pleading first and then the award, because my lords, it becomes very clear then sequentially what the claims were. My lord, the statement of claim is page 45 of the appeal memo. And the basis of the claim, my lord, is set out at page 54. I'll just read that out. My lords have page 54, my lords, last paragraph on page 54, paragraph 15.
Yes.
Under the circumstances, the respondent is liable to pay the claimant of a sum of rupees 2.68 crores towards the principal amount outstanding, calculated as follows. Total invoices raised by UHPL on HAL 14.87 crores, less total payments received from HAL 11.88 crores, less admitted and accepted deductions 31 crores. And therefore, my lords, the total dues.
This was the total claim.
This was the total claim, 2.68 crores. On this basis, my lord, the arbitral tribunal framed issues in respect of all these issues. And my lords, the arbitral award starts at page 70. The issues are at page 84.
What happened? Did the third arbitrator give its award? No.
I don't think that has happened, my lord. There was a challenge. He refused to sign, is what I'm told. But my lords, I was not privy to the arbitration.
No. 84 are the
Page
issues.
84 are the issues. My lords, on all the invoices. And my lords, in all respect of all this, the arbitral tribunal concludes that there is no non-payment of invoices. Those, your lordships will find in respect of issues 1 and 2 at page 109. Then issues 3 and 5 rejected, my lords, at page 137 and 138.
No, on 1 and 2.
Page 109, paragraph 47, my lord.
Okay.
1 and 2 not established. Then, my lords, 3 and 5 are also rejected. Paragraph 92 at page 137 and 138.
Hmm.
1 and 2, my lord,
You said 157, no?
my lord, 3 and 5, 137, my lord.
130.
137, paragraph 92.
Yes. Then 6.
6, my lord, is discussed from 138. the finding on issue 6, my lord, is at page 139 and, sorry, 140 and 141, my lord.
Rejected.
My lord, here this is an issue in our favor, where the respondent proved that the payments were made after scrutinizing the invoices and the TDS certificates were correctly forwarded. So therefore, my lord, the deductions that we made in respect of the invoices were held to be correct. As far
So
as
rejected,
issue 6,
claim rejected.
the claim is rejected. After all that, my lord, at page 10, at paragraph 103, page 144. Well, it's paragraph 103, if I may be permitted to read, my lord. At 144. It is no doubt true that the claimant has claimed full facility maintenance charge, fixed maintenance charge, for which the claimant is not entitled as per the true interpretation of the agreement. But that does not prevent this tribunal to award certain amounts towards loss sustained by the claimant. For the foregoing reasons, we hold that the claimant is not entitled for the amount of rupees 2.68 crores, which is its claim, as sought for in the claim statement. It is not possible to calculate loss sustained by the claimant by a profit and loss statement, as no figures are available, and the period of contract spread over from the years 2005 to 2010. It is not possible to fix the compensation in this case by arithmetic precision. However, taking into consideration of all the aforesaid facts, we hold that the claimant is entitled for certain sum as compensation. The claimant has contended that straightaway the claimant is entitled for rupees 16 lakhs on the ground that the amount payable by the respondent as per its own case is so and so, but paid only so and so. This is neither pleaded nor substantiated by evidence. On the other hand, for the first time, it is mentioned in the final accounting and also written argument submitted by the claimant, and we cannot accept. Even otherwise, the amount of compensation awarded would take care of all these claims. Taking into consideration all the facts and circumstances of the case, we award a consolidated sum of rupees 60 lakhs, which is inclusive of the proportionate cost in favor of the claimant.
What does the 34 court say on this?
The 34 court says that we have not specifically pleaded that the award is against public policy, and therefore if patent illegality is the ground.
You say
None of this is then 34, my lord.
Pardon?
None of these raised in 34. Kindly take page 41.
How would you justify?
My lord, there are two aspects to this. None of this was before the lower court. There are only two grounds that they say. May I just make a
He will.
There are two aspects to this, my lord. A section 34 petition was filed, and it's the only ground pleaded is only two grounds. Kindly take page 41 for a moment, my lord.
Will it not come in public policy?
They have not even referred to that. What they have said is that there has not been appreciation of evidence, not pleaded at all. The only thing that comes out of it is that it's not been pleaded over here. On the basis of that, I'll file my statement of objection to the petition itself because
We'll hear you.
my lord, I'll prepare for this.
You will,
At the end of the day.
The complete record is here, na?
Yes, my lord. I'll file an
Would you justify this? We don't require this award is enough.
We had focused on the aspect of the section 34 petition filed, but none of this was
Tell us
pleaded.
one thing. Claims rejected?
My lord, the
Claims rejected?
claims rejected over here.
Where is the basis for compensation or
So
damages?
far as the aspect of issue 7 is concerned, with the issue framed with regards to the award entitlement, my lord.
Where is the issue of damages here?
Lord, whether he's entitled is the issue framed, issue 7.
Pardon?
The claim was for 2 crores 68 odd lakhs. Whether he's entitled or not was the issue, my lord. On the basis of this, the arbitral tribunal have
What
come.
is he entitled to the claims made?
So on the basis of that, they've come to this conclusion. Yes, my lord. I seek to justify. I'll file objections to this and have this matter done, my lord. May we give an opportunity for week, my lord.
Why do you file? You say everything is there before you.
Then, my lord, I'll argue next week, my lord. I'll prepare myself on this specific aspect because it's not forthcoming from the document that has been filed, my lord. Section 34 speaks only on this aspect.
Let's go by the reasoning of the learned arbitrator, the tribunal. Let's go by the reasoning.
Very well, my lord. I'll prepare myself in that aspect and argue next week, my lord.
Very well. When do you want?
When would you like to have it?
Just have it next week.
One other matter that was there after 2 weeks. It will be in the first week of November after the vacation.
We will have it. Just give it 28, 29.
29, 10.
No, it could be in November, just after the vacation, this Diwali vacation.
Give 5th or 6th, 7th, 6th, 7th.
7th?
7, 11, sir.
Great.
7, 11.
Deep request.
We have heard the learner senior.
I understand,
counsel
my
for the
lord. Thing is, this is the not coming from any of the aspect, my lord. That's why I'll prepare myself and make my submission, leave it to the handler.
Surely this, definitely we want that assistance from you.
Yes, my lord,
Maybe-
definitely.
maybe on a prima facie.
I understand, my lord.
We
My
want
only
an
difficulty was that I confined myself to what has been in regards to the pleadings, even the appeal as well on this aspect. I'll prepare myself and argue on 7th, my lord. I'm grateful for the indulgence.
Yes, we have heard the learned senior counsel for the appellant to come up for the arguments of the counsel for the respondent who seeks some time to prepare the matter.
Yes, my lord.
7-11,
Grateful, deeply grateful.
number 13, Shirakshit R. Thirteen,
This password.
serial number 14,
Here for the respondent, my lords. I pray for some time, my lords. May I request it? I pray for some time. I'm for the respondent,
Why?
my lords. Section 30, my lords. I need to produce some case laws that I'm relying upon, my lords, in view of the.
You want to
position-
produce?
Some case laws, my lords. There is a modification of the award. They have basically contended that.
Let's see that, let's see, where is the modification of the award by the 34 court?
Yes, my lords.
Let's see that.
Lords, there are 33 my lords.
It's only the interest which has been modified. The period of interest, that's all.
My lords, the honorable arbitrator holds that there is a breach of contract, my lords. I am the claimant, breach of contract, but dismisses my claim and allows the counterclaim, my lords.
See, you see, come to page 56. The imputed award passed is modified by setting aside. See, on a principle, you may be right, could not have done that, upheld or reject. By setting aside the award insofar as holding that the respondent defendant
herein is
herein
entitled to recover
is
some relief.
entitled to recover this along with interest at 18 from 27/1 till actual payment. What does he want to say? Is it that in principle 42, 40, 44 has been upheld?
My lords, this is a claim which is made by the counterclaimant, my lords,
You say by them?
by them. There is a claim and a counterclaim, my lords. My lords, having held that there is no breach, there is a breach on the part of the.
No, we want to understand what is this direction, what is the conclusion? The impugned award passed is modified by setting aside.
The award insofar as.
So this has
holding-
been set aside.
Yes, my lords.
This has been set aside in your favor,
Yes, my lords.
in your favor.
Yes, my lords.
So what has been awarded by the arbitrator on their counterclaim against you
Has been set aside.
has been set aside, very well. And the next part is the impugned award holding claimant paying entitled to receive 46, this till date is not disturbed. So effectively, this is an award in your favor. This is an order.
Yes.
Now, they have to argue. That's right.
Yes, my
So
lord.
it's not that, in that sense, it has been
Modification.
modified. It's not that.
My lord, senior is engaged in some part-heard matter, my lord. Kindly have it tomorrow or day after, my.
Just say adjournment sought on behalf of the council for the appellant adjourned.
26-11,
My lords, may I request on 28th, my lords, some inconvenience on 26th.
Just give.
28-11,
Much obliged.
for 15,
Appearing for the appellants at 15.1, your lordships, I request a short passover in this regard. We've engaged senior counsel in the
Who is
matter.
in 15?
15,
You're in.
I'll undertake to file power. In the connected matter, I filed power. The parties are the same.
We'll record that. Please. You think she wants a passover, we'll make an attempt. Then we'll have it some other day.
Some other day, please.
Indeed.
You have filed in 15.1.
Yes, please.
You appear for in 15 also?
15 also, same parties.
Just say that, at the request of counsel appearing for, just say that Mr. Bhuvanendra Raju,
Yes, please.
advocate, appears for the respondent, states that he shall also appear in MFA 8462 of 2022 and shall file wakalat within 1 week. Start noting the said submission, re-notify both the appeals on.
A set of papers.
Let a copy of the appeal, just give it to him.
Please.
Be given to by the counsel for the appellant to Mr. Raju within 1 week.
1911. Serial number.
Lordships, some inconvenience on 19, any date after 20th, your lordships, my seniors on.
2611, madam.
Please.
Serial number 16, Shri Harish Kumar, 16.
My lord, I appear for the appellate in this matter. My lord,
Yes.
it was short accommodation. It's
Why?
big. So I've got some durations.
Pardon?
I'm not well, my lord.
Okay. The counsel for the appellant stated to be unwell, we notify her.
Twentieth 11. Serial number 17, Shanjan Kumar, 17.
My lord, in this case, it was instructed by the party that the matter has been settled and
You are appearing for whom?
appellant.
We want to withdraw this?
No, the settlement letter has to be issued by respondent. Therefore, we are waiting for that. That's why it is not necessary.
Appears for the respondent.
Or it is not issued notice until
When do you want?
1 month time.
Why 1 month?
Approval has to be given by respondent. That's procedure. There has to be approval by authorities of respondent. Approval letter has to issue. That's why.
When did they tell you that they have settled the matter?
No, if 1 month time is given, I will file memo.
Not 1 month, we will issue notice to them then. Let them come to the court.
If notice is issued, already it is settled. That's why.
They are not aware of these proceedings.
No, not aware. That's why.
So we issue notice.
Settlement arises. That's
Take it back. We'll give you 15 days to
Yes.
get it processed. At the request of counsel for the appellant, re-notify. Just mid-November, ma'am.
1411. Serial number 18.
In this case, same issue notice to respondent.
Same matter.
In this case, it has to be issue notice to respondent.
Why? Then we'll hear you. This is a different bank.
Yes, sir. In this matter, during the COVID-19 matter, without servicing of notice to the appellant hearing, the proceedings were held by the arbitrator, and without
What does the 34 court say?
which has been confirmed by the award passed by the
No, on notice. Your whole case is notice was not issued.
notice not served to the
Very well. Now, what does the court say here?
Court's appellate court is saying that it is not necessary to servicing of to once it is notice issued the correct address, it is enough. The 34 court is saying duly issued to the correct address, it is enough as per the this one is wrongly held by the 34 court. Even without producing any documents to the claim, the learned arbitrator has allowed the entire arbitration petition on the basis of claim petition filed by the respondent. Page number 44 of our.
You were the borrower or the guarantor?
War over.
Where did you take this point that the arbitrator did not issue notice to you?
Only after receipt of award only I came to know about the.
Where do you say so? In your section 34?
It's mentioned, my lord.
To us?
Yes, yes.
Where is that?
Page number 30 of judgment. Therefore, it is clear that the above notice and intimations were sent to the petitioner by registered post and their correct address, and therefore under the law there is a presumption of due services when notice are sent to the correct address.
Where are you reading?
Paragraph number.
Page number 30, para 22.
Which line?
In judgment page 18, last 4 lines, my lord. Therefore, it is clear that the above notice and intimations were sent to the petitioners by registered post and their correct address. And therefore, under the law, there is a presumption of due service of when the notices are sent to the correct address, though registered post, it is to be noted that copy of award dispatched to the petitioner at the same address by registered post is admittedly duly served. Therefore, there is the inference that the earlier notices or intimations were also duly served.
How much is the liability?
35 lakh.
Who had appointed the arbitrator?
One Bhaskar has appointed as a first arbitrator. After his demise, the second arbitrator appointed as the arbitrator. Even though after appointing of second arbitrator also notice has been not served to the petitioner. Even for appointment of arbitrator also not served.
Issue notice. Issue notice. Returnable law.
1712. Serial number 19 adjourned. 20 adjourned. 21 Shri Nikit Bala. Number 21.
Lord, we've engaged senior counsel in this matter, my lord. He's in another court hall. He's requested for an adjournment, my lord. We're also filing a brief synopsis on the matter, my lord. The lordship may kindly have it either tomorrow or the day after tomorrow, my lord.
Yes, Mr. Naganan. What is?
He had just informed us, my lord. We were ready otherwise.
54.
Concurrent findings, my lord, the learned arbitrator and also the challenge court. Of course, they are now before your lordships. Question is of painting, my lord. Painting of Raja Ravi Verma, it was held out to be so. Turns out that that is a fake. I paid 50% of the money. There's a direction now for restoration of that money. I was only thinking, Lord, they don't seem to have filed the paper book. Of course, the lower court records will be available, but it may be not troublesome for both your lordships to look at the same record. There is some relevant papers they would like to file, my lord. It may be convenient for everybody. Otherwise, we can argue,
Just say
Lord.
that. When do we re-notify? Just say re-notify all. When do you want? You see November last week, see subject to our.
Sir, 2711.
Will it be 28th, madam?
2811.
Please.
Serial number 22.
22 for the response counsel.
Yes.
IPO for the response counsel.
22.
There's 22.
22, please, my lords.
You just call the council. Think,
Sure, Prakash.
See, seems to be some confusion.
Please, my lords.
In the morning, one counsel appears and mentions,
Please, my lords.
he mentions 11, thinking possibly he is mentioning 22.
Please.
Something that's happened. We adjourn it, he may be under the impression the matter got adjourned. But, that's how we will just try to call the counsel. At least he should not go unrepresented. Just try to call him. We'll just pass over.
Please, my lords.
Next, just call the next one.
23. Serial number 23, Shivek Hola.
Yeah, for the.
Yes.
For responding.
There are two matters now, Mr. Ola. What is,
Lord, the arbitrator
Yes.
passed an ex parte award against which, my lord, we filed a section 34. Against which, my lord, that also, my lord, confirmed the award, and then we are before your lordships.
I was ex parte, but notice served?
According to us, notice is not served. According to them, notice is served. That's the issue, my lord, which your lordships will have to decide.
Yeah.
In fact, I've prepared a short list of dates.
In both the matters, there is a connected also appeal.
There are two appeals, my lord, as against respondents have filed. Before the claim petition, my lord, that I have filed claim petition. There are two respondents that they have filed
So
two
both has
appeals.
filed separately,
Yes, separate.
but they were both separately before the 34 court also.
Yes. Original records also placed before. original
We just want to see whether notice has been, what is the finding of fact by 34 court?
34, my lord, says that, my lord, it is served. But then, my lord, it is not my signature. That's what, my lord, we have specifically contended. Comparison signature will make out it is not. And, my lord, the so-called acknowledgement, my lord, the claimant produces it before this honorable court. It was not produced before the lower court.
What did he produce?
Acknowledgement, so-called acknowledgement, which bears somebody's signature, not my signature.
Why
Postal
did he?
acknowledgement. I don't, that's what, my
No,
lord,
but no, was it an acknowledgement card?
postal acknowledgement.
Post acknowledgement card.
With
Obviously, no,
seals.
but he would receive it back, no? Once it is acknowledgement
No,
due.
my lord, what happens is, it will be, my lord, the arbitrator sends the notice. Has he sent the notice or arbitrator sent the notice? If the arbitrator sent the notice, how does he get, my lord, the acknowledgement?
He
That
would
is-
get it. Arbitrator would have it. That's it.
Arbitrator, my lord, with consent by taking signature from the complainant respondent, has handed over the original documents to respective parties. Accordingly, my lord, arbitrator has written and copy also has been sent with order sheet.
Should that notice acknowledgement should be part of the arbitral record.
That is what, my lord, because that is there in the
Let's see that.
Yes.
Where is that acknowledgement due?
kindly thing. That original records are there. We have produced that original records, which is given by the arbitrator. That was considered. Original records. We have also produced.
I'm not a party to the agreement. I had purchased the property, my lord, even before the claim statement was filed. I was made a party, and then, my lord, the arbitration went on.
Oh, you are not a signatory there. This is the issue, subject matter of the issue is what, the house or anything?
Specific performance, my lord,
Specific
site,
performance.
a site, my lord, a large site.
And and you bought it from whom?
From, my lord, the original owners.
Original owner?
Yes, they were
And
parties.
who is he?
He is, my lord, the so-called agreement holder, claims that, my lord, it was earlier.
Agreement with the original owner?
Yes.
During the pendency of section 9
Ultimately,
petition.
my lord, sir, merits must be gone into.
Yes.
It can't be, my lord, ex parte, my lord, therefore, in I, my lord, the valuable property I have paid, my lord, 6.5 crores. How much have you paid?
That cover only they know.
Sorry, 2.5 crores.
Yes.
Therefore, And my lord, his my lord, agreement is my lord for a far lesser amount.
No,
50 lakhs.
specific performance granted.
Yes.
With the
My salary is
right.
set aside. I'm not even, my lord, heard. Ultimately, my lord, justice requires to be done.
During the pendency of injunction which is granted against the original landowner that they have sold, and my lord, seal deed which is executed before my lord, in the year of 2012. Injunction granted my lord in section 9 petition restraining them to not to create third party interest in the year of 2008, and which is my lord served on the owners, and owners appeared before the section 9 petition before the civil court earlier. Then my lord, the claim petition has been filed. Claim petition notice has been issued, order sheet, and the judgment clearly speaks that they have served, and acknowledgement having serving the copy which is available.
No, owner is from whom they have bought it.
Owner, since my lord, that he has executed agreement of sale, that is joint development agreement with a condition of agreement of sale in the JDA, and thereafterwards, my lord, there is a litigation, and we have sought it out litigation.
But they were not party to.
They were not party, but they are aware, because my lord, that this, they are aware of the my lord proceedings, they are a party to the claim petition.
Will that be enough? Enough?
That merit, my lord, because my lord, the merit your lordship can consider, please.
Today only on the issue of service. Okay, wait, do we have that acknowledgement card?
Yes, everything.
Sure.
In fact, very curiously, trial court, my lord, in section 34 says, I was impleaded in the CMP before this honorable court. It is not so. In
Huh?
fact, page 339, trial court, my lord, in section 34 says, on account of the fact that they were impeded by parties in the arbitration proceedings as per the direction of the Honorable High Court of Karnataka. I was not made a party at all. I was not even a party, my lord, before the High Court. And there was no direction to make me a party. That is also we have placed before your lordship's order of the.
And do we have that? Huh? Okay. I think the file is in the branch. Is in the branch, ma'am?
No, original records last.
But the acknowledgement was with you. You present.
No, my lord, what happened, my lord, that order sheet, if your lordship speaks of arbitrator, with consent of the both parties, this documents, my lord, original exhibits has been handed over, which is produced in section 34 petition. And thereafterwards, my lord, the call for record. And original acknowledgement, which is, my lord, handed over with consent of the, my lord, parties before the.
So after that is after culmination of the proceedings.
Yes, my lord.
Section 34.
Therefore, that
my
we
lord,
have produced as it is, arbitrator seal is there, everything.
Like this arbitrator.
We
has
can't, my lord,
handed over the original record to him.
that is order sheet speaks.
Before the learned 34 court, this acknowledgement was not placed. Only before your lordship it is placed.
No, we have placed, that has been considered. My lord, that I'll place before.
Okay, just get the record, ma'am. Just say that re-notify for hearing on. Counsel for the parties to file the written submissions.
Already, my lord, the synopsis has.
They are there, just cut it, cut the last one. Just give it in November any date.
Sir, 27/11.
27 long date, so short date because parties. Short date may be given.
Yes, what, this is short only.
Our senior is acceptable on the second week or first week of.
Not first week, just give it third week, ma'am. Just give it third week.
20th, sir, 20th of November.
Please.
28th of?
November.
What did we?
20th is a Wednesday, my lord. It's a normally I thought it was a taxation day on your in your lordship. No.
Monday we are.
Monday. Oh. Very well. I'll be here. 20. But
The 28th, right? Next.
please.
Meanwhile, that original records may be ignored.
We are calling for it.
Please.
Let the.
Twenty-four adjourned, 25, Srini Krishnan.
Yeah, your lordship appearing for the respondents in serial number 25, seeking a short. Yes, your lordship.
this side.
Apologies, your lordship. Seeking a short adjournment, your lordship.
Why, ma'am?
Your lordship, the clients are willing to engage a senior in this matter, your lordship. Hence, a short.
His mic, madam.
The clients are willing to engage a senior, your lordship, in this matter. Hence the accommodation.
Just 1 minute.
And this matter will be taken up on Wednesday then, my lord. I'm actually ready for that. Want an accommodation, but my lord, Wednesday.
Just 1 minute. Which number, ma'am?
Serial number 25.
25. At the request of counsel for the respondent, re-notifier, which is not opposed, re-notifier.
My lord, Wednesday, my lord, in fact, this short point. Very, very short point.
You give me date convenient also. We have to see our board also.
Pleasure.
13/11,
Next.
26. Serial number 26.
Lords, I appear for respondent numbers 1 to 3. We mentioned the matter in the morning. It was for hearing by the appellant. We've been informed by the appellant counsel in the morning that they've given an NOC, but the new counsel has not yet filed their wakalat. So if the date may be fixed after 2 weeks or so for hearing.
The learned counsel for the respondent states that she has spoken to the counsel on record of the appellant, who stated that he is no more the counsel. He shall not be appearing, who stated that he shall not be appearing for the appellant, as the appellant has engaged a new counsel. Noting the submission, re-notify.
My lords, if I may just clarify, I'm only for respondent numbers 1 to 3.
Yes. Say respondent number 1, 1 to 3.
1 to 3.
4/12.
Great.
Serial number 27. 27. Bakirappa.
None for the appellant, re-notify.
16/12. Serial number 28. Serial number 28.
Yes, ma'am. Just wait. We'll just pass over.
Lords, I'm told that there is a connected matter, which is MFA 62, my lords, which is not before your lordships from the list.
Why is it connected?
My lords,
Same award, man.
Same award.
what happened was, because there were two cross petitions to set aside the award under 34. My learned friend's client has preferred appeals under 37 from both of them, because two different 34s were registered. So there are cross petitions. That's it.
But the appellants are different.
Appellants are the
Same,
parties.
are same.
Then why against a common award to?
Lord, what happened, as yesterday we submitted that as far as the first contract, about 7 lakhs and odd was due to me. And
On the
yes,
second.
that there I was asked to pay 2 lakhs, repay 2 lakhs to them. That I questioned in under section 34. And as far as granting the cost of additional work, about 28 lakhs, that they questioned it. So there were two
34 petitions
before.
What is the date there? What is the date there?
Pardon me?
There is no date.
Both were coming together. I don't know. I thought that it is there, the record is there along with that.
In fact,
Both were coming
the
together.
department brought it to my attention last evening.
What is the number?
62 of 2022, my lords.
Just why don't you file a memo? Get a memo, we'll get it listed.
Yes, Lord, I will do that.
Just give it to us, possibly post lunch, give it to us. We will call that also.
I had some difficulty post lunch, my lord. I'm ready in the matter.
We will only list that appeal along with this. Because it is arising, let's hear it both together.
That's precisely my submission. If your lordship may even direct, my lord.
Or you can file a memo, show us.
I'll file a memo. Your lordships may record that I filed a memo. I'll hand it over to the office, my lord. I'll do it right away, my lords.
We'll just pass over, get a memo, we'll get it listed that also.
Very well.
Because that will come before us only.
Precisely.
It has to come before.
It's the same year. It's in fact just one serial.
Yes.
And I'm ready in the matter, my lords. Only post lunch I have some difficulty.
Get a memo, whosoever, whether you want or you will get it.
I will do it right away, my lords.
Okay.
I will do it right.
Next, pass over.
29. Mananagana.
The appellant.
Yes.
Not there are not 4 cases which arise, 3 of them arise from the same common award. There were 3 disputes before the arbitrator, and each of them not had their respective fates, and now we are before the court. So one matter is listed before your lordships is today, my lord, 104 of 22. I have a memo, my lord, which points out that there are 2 other cases arising from the same award and one more arising from the same contract, but for a subsequent period. Same contract, same parties. So I've given all the numbers, my lord, they may all be connected. Your lordships could kindly see the memo. 104 is listed now today, my lord. 102 and 103 arise from the same award, which is subject matter of 104. And 241 arises from the same contract, but for a subsequent claim between the same parties.
But the arbitrator was common.
Common, my lord.
All 3.
All 3 common. It's the same tribunal.
For the respondent, no objections.
These would all come here now. Eh? These all matter. Let's check up. Here, no? Say that Mr. Nadanand, the senior counsel, appearing for the appellant, has filed a memo as through Mr. Pradyumna KV has filed a memo which reads as under. He submits that COM AP 10222 and 10322 arises from the same impugned award. He also states COMAP 241-2022, though for a different period, is between the same parties.
And arises from the same contract.
Arising from the same contract, and request that these appeals be also listed along with this appeal. Full stop. The learned counsel appearing for all the respondents.
All the respondents.
All the respondents has no objection in that regard. The appeals being of the year 2022 be listed along with this appeal on the next date of hearing.
Will be 12th or 13th if possible.
Taken on record, just give 13th.
Grateful.
13-11. sir.
Great.
Till number 30.
For respondent.
Kindly
Yes.
pass over the matter, my lord.
Huh?
Kindly pass over the.
Pass on.
One submission, Lordship, with great respect to counsel. This matter, this is the concurrent finding of the court, Lordship. Kindly see the order.
We will see.
My lords,
Actually,
kindly
so
pass over, my lords.
Pass over, we'll see it. Okay. Next.
31. Serial number 31.
My lord, kindly pass over the matter. We are ready with the matter. Senior is held up in other.
Pass over.
Pass
All
down
the
matter.
passovers.
Serial number 7. 7.
Yes, come.
That's one respectful submission, my lord. Serial number 23, interim order has to be extended, my lord. Now, the lords have given the date, that matter, for 20th.
Interim order, if any, shall continue till the next date of hearing.
Much obliged.
Yes.
Here, this is matter arising out of the award passed by the learned sole arbitrator. This is wherein the respondent and the appellant entered into an agreement dated 31/7/2010. This is the agreement, my lord. But, the terms of the agreement, my lord, has been extracted by the learned sole arbitrator, my lord, in his order. But at page 57, but the relevant clauses have been extracted by the learned sole arbitrator. But the appellant was asked to negotiate with the owner of the building to purchase the property, for which 75 lakhs to be paid, advance as an advance. 25 lakhs was paid by the respondent to the appellant. But the terms of the agreement, my lord, provides for a fixed period of 6 months. The validity of the term was for 6 months. And clause 9 provided for the termination. Termination says by giving 30 days notice. And thereafter, 15 days time, my lord, to initiate proceedings. But especially clause 20, my lord, which says time as the essence of the agreement. But this arbitration proceedings were initiated.
How much you are paid? 25 lakhs.
Yes. That is not in dispute.
And what was your claim? 75 lakhs.
The term of the agreement was 75 lakhs on the completion of the job.
But the job was not completed.
The job was not completed.
So they sought refund of 25 lakhs.
Yes, my lord, according to us, after 6 years, my lord, of the agreement. Therefore, according to us, my lord, the claim is time bound. The learned sole arbitrate, my lord, rejected our contention on the ground that while referring the matter, the learned single judge in CMP had dealt with that issue. But at the time of the admission, my lord, when it came for interim passing of the interim order, had relied upon the judgment of the Supreme Court, my lord. There the period of limitation is 3 years and Article 137. Therefore, my lord, in fact, after hearing only, this honorable tribunal was pleased to grant the interim order of stay, subject to depositing this is, my lord, this case, my lord, similar to the case on hand, according to me, my lord. See, after 5.5 years, my lord, the arbitration proceedings were initiated. My lord, the relevant paragraph would be at, my lord, para 11 of the particular judgment. My lord, para 11, shall I read? It is now fairly well settled that the limitation for filing application under section 11 would arise upon failure to make appointment of the arbitrator within 30 days from the issuance of the notice invoking the arbitration. In other words, application under section 11 can be filed only after a notice of arbitration in respect of particular claim or dispute to be referred to arbitration as contemplated under section 25 of the Act. No. Thereafter, my lord, while to get issue notice itself, my lord, there was a delay. Madam, shall I draw your lordship attention to paragraph 15, my lord, it has been dealt with, my lord. The reasoning in all these judgments, referring to all the other Supreme Court judgments, the reasoning in all these judgments seems to be that an application to section is to be filed in a court of law. And since no specific article of limitation applies, the residual article would become applicable. The effect being that the period of limitation to file an application under section 11 is 3 years from the date of the refusal to appoint the arbitrator or on the expiry of 30 days, whichever is earlier. But thereafter, the Supreme Court has relied upon other judgments also. The main finding, my lord, is at paragraph 21. But in that case also, my lord, the honorable apex case has.
But the earlier round of litigation, the High Court holds against you on limitation.
Yes.
So how would you come? Did you challenge that order?
I relied upon this Supreme Court judgment, my lord, saying that I will straight away take you.
See, you will not argue an appeal against CMP order that has attained finality. The court holds, the claim is not barred
Yes.
on limitation. That's the end of it.
But my submission to lordship is now in view of this judgment.
Okay,
Well,
then you
I
should have
understand
challenged
your
that.
lordship's mind. So
Then you
since-
should have
since-
challenged that.
Since the CMP, the order passed in CMP at a time of
right.
finality. But my lord, my submission would be this, according to me, this is the law now.
It may be.
Therefore, my lord,
Inter se parties, it has attained finality. Let's be clear. We will not accept that plea.
therefore,
Otherwise, everything gets reopened. Change in law, open it.
not like that, my lord. Shall I read my para 38 and 39?
So you may be right,
Yes,
but there is a finding against you which has attained finality.
that's right.
Let's leave it at that. Is there any other point?
I rely upon only in this judgment, my lord.
That's all.
saying that
We will not
because
accept that.
they have
That's against. Now today you are effectively arguing as if this is an appeal against CMP.
No, because it's a continuation of proceedings.
Oh, nothing doing. We will not take that.
You see, arbitration and
no.
this appeal is also continuation of this.
Oh, no. These are different regime. These are different proceedings. That was appointment of an arbitrator.
That's right.
Arbitrator appointed, you took a point of limitation. Maybe at that point, even the limitation could have been gone into. Today, everything has to be left to the arbitrator to decide, including the point of limitation. You have taken that risk, you argued limitation, the court rejected it. You did not go in appeal.
It was not challenged. That order passed by the Leonard Singh was not challenged, and therefore, parties.
What do you say?
participate. That in fact, my lord, that issue of limitation was raised before Leonard Single judge, my lord. He dealt with extensively.
Right.
My lord, at that time, my lord, the section 6A was not there.
You're right. That's the
And then, my lord,
interpretation.
SVPK co was applicable, 7 judges bench judgment, my lord. The order passed by the court under section 11 is
Yeah,
a
yeah,
judicial
that's
order. It is not an administrative order.
Okay, that's all. So let's sit down.
Yes, please.
That's all. Anything else?
My lord,
Okay. That is all the submission.
of course, my lord, that's legally, my lord, that is my submission.
Okay.
On the ground of limitation, we attacked before.
Okay.
So
The
arbitration
challenge in
tribunal.
this appeal is to an order dated 5th February 2020. Passed by the Leonard 6 additional civil and sessions judge at Bangalore City in AS number 51 of 2014, whereby the Leonard trial court, just trial court in short, has dismissed the petition filed by the appellant herein under section 34 of the Arbitration and Conciliation Act 1996. They say Act of 1996 in short. Full stop. Some of the facts to be noted for the purpose of this, for a decision of this appeal are that the is the impugned order. Where is the impugned order? Which page is that trial 34 petition order?
My lord, that page 51, my lord, is the award of a sole arbitrator.
No.
My lord, the judgment, my lord, that is at page 20, it starts at 20, 19,
Yes.
19 onwards. my lord.
Are that the appellant herein, appellants herein, there are two appellants,
Yes.
two appellants had undertaken a liaison work,
One
liaison
clarification.
work.
In fact, my lord, had impleaded the second appellant as a respondent because it was a proprietary concern of the appellant. Now I filed an application to transfer the second respondent as an appellant number 2.
What do you say on that application?
Milord, I have filed objection, Milord. He is a proprietor. First appellant, Milord, is a proprietor, second appellant. Both of
That's a
them are the
propri-
respondents,
That's a,
Milord.
that's a proprietorship
Yes,
concern.
yes, Milord. Proprietorship is concerned, Milord. That's it.
I don't see why there should be an opposition. Both were claimants, both
Yes,
were
yes,
respondents
respondents.
before the arbitrator.
Yes, please.
Even if we transpose, what difference it would make?
Makes no difference. Milord.
Have you filed amended memo of parties?
No, my lord, I have filed application to come to transpose.
We allow that.
Well, very well, absolutely. I will carry out
You will carry what?
the amendment, my lord, showing I will
But
delete
we are dismissing this.
much of the.
Just say this, there is one application before this. No, retain it. Just IA 2 of 20, 2 of 23. This is an application filed by the appellant stating, seeking the following relief. Seeking the transposition of second respondent as second appellant. Full stop. Though the objections have been filed to this application.
Please.
By the respondent, comma, the counsel for the respondent has no objection as the respondent number 2 was the respondent before was one of the respondent before the arbitrator, learned arbitrator. And also the appellant before the trial court. He was the appellant.
Plaintiff.
Accordingly, the application is allowed. The learner counsel for the appellant shall make necessary corrections in the memo of parties. He shall additionally file a memo of parties in the registry within 3 days from today. The registry shall, on filing the same, the registry shall make it part of the record. Full stop. Application disposed of. We have heard the learner counsel for the parties, then that will come. Okay, then say this, the case of the appellants was, it is noted that the appellants, appellant number 1 undertook a liaison work, LIAISON, for the purpose of selling a property being 45/1 Magarth Road, Bengaluru, belonging to Indian Telephone Industries Limited, ITI in short, in favor of the respondent herein. Full stop. It was agreed between the parties that the respondent shall pay an amount of rupees 75 lakhs as fee to the first plaintiff, and in furtherance thereof an amount of rupees 25 lakhs was paid through check. Full stop. It is also a conceded position that there was a service agreement executed between the parties dated 26/4/2006. Full stop. It was also agreed that in the event of failure on the part of the plaintiff number 1 to get property by ITI in favor of the defendant, the plaintiff shall refund, plaintiff number 1 shall refund the amount received as the advance together with interest. Full stop. It is a conceded position that the plaintiff number 1 failed to get the property in favor of the respondent herein, and also in terms of clause 9 of the service agreement dated 26/4/2006. The defendant got issued a notice dated 31/7/2010. Full stop. The same was followed by another notice dated 11/10/2010. Full stop. On failure to comply with the demand made by the respondent herein, the respondent had filed a CMP number 10 of 2011 before this court for appointment of an arbitrator. As concedingly, there was an arbitration clause in the service agreement dated 26/4/2006. That's right.
Yes.
Full stop. This court, while allowing the application, has passed a detailed order. Full stop, it is need to be mentioned here that while the appellants herein had taken a point, had taken a objection that the claim made by the respondent herein is barred by limitation. Full stop. The court, vide its order dated
20th September 2011.
20th September 2007. 11. As on the issue of limitation. Has in paragraph 15.
Thirteen, 14, 15, 3 paragraphs.
13, 14 and 15.
15.
Which page is the order?
But this I have produced along with the objection, the order of this honorable court.
13, 14, 16.
Please. 13, 14, 15, 3 paragraphs.
13, 14, 15.
Yes. Page 21 of the objection.
20.
Just shall I make it available to the court, my copy?
Is the objections there, ma'am?
Yes, I have.
Which we should see it's all part of our record.
Yes, it is filed by me, Millet.
And they please.
Yes.
Filed on 10th.
Memo filed by the appellant.
Is it there?
They dated 27/3/2023, even in my objection also.
Which page is that?
So he has filed the documents on 27/3/2023. The appellant only has filed.
Okay. Which page of that?
Page 21, Millet. It starts, Millet, I think page 12, Millet.
Page?
12, Millet. 1, 2. That para 13 is at page 21, Millet. What up, sir? Memo is filed by the appellant.
Ma'am, just show it to him.
Millet,
Show it to him.
yes.
Your objection dated?
Millet, this is, the memo is filed by the appellant, my objection.
Just take it from there.
We have just taken it.
13, 14, 15. Full stop.
Yes.
Full stop. The learned, the claim of the respondent before the learned arbitrator was allowed in his favor against the appellants herein. On the plea of limitation, the learned arbitrator has held as under, where is the award?
What up, sir?
Yes. Okay. Where is the award on the limitation? Where does the?
That is, it is at page, Millet, it is 64, Millet. Of the appeal memo. Appeal memo.
That's the arbitration's award.
Yes. Yes, arbitrator award. Arbitrator award, my lord.
Has in paragraph 13, page 63, 64, has held as under. Suffice to state that the plea of the learned counsel for the plea of the appellants on limitation was rejected by the learned arbitrator based on the order passed by this court in the aforesaid CMP. Today before today before us, the submission of the learned counsel for the appellants is an identical one that the claim of the respondent before the arbitrator for an amount of 725 lakhs was a stale claim and could not have been granted by the learned arbitrator in favor of the respondent. So we find that the learned trial court has also, for similar reasons,
Para 20, page 41.
for similar reasons at in paragraph 20. In paragraph
Page 41.
in paragraph 20 as stated as under. Twenty and 21, 22, 23 as stated as under. And 24. Good stuff. Good stuff. If that be so, comma, the plea of the learned counsel for the appellant cannot be accepted. Good stuff. The learned counsel for the appellant would submit that in view of the judgment of the Supreme Court in the case of Bharat Sanchar Nigam Limited and another versus Messrs. Nortel Networks India Private Limited, comma, the period of limitation could not have been the plea of limitation could not have been rejected by the learned arbitrator. Good stuff. By the learned arbitrator. Suffice to state that in view of the conclusion of the learned of this court in CMP so and so, comma, wherein this court had conclusively held that claim filed by the respondent is a live claim. In view of the position of law as was existing then, having rejected the plea of limitation of the appellants, and which order has not been challenged by the appellants in a higher forum, comma, we are of the view that the learned arbitrator and as well as the trial court were justified in rejecting the plea of limitation, oblique the appeal filed, oblique the challenge made to the order passed by to the award passed by the learned arbitrator under section 34 of the Act of 1996. The aforesaid being the only plea urged by the learned counsel for the appellants, comma, the present appeal is also without merit and dismissed. Thank you.
He has deposited, there was an execution petition filed. This court directed to granted a state to subject to deposit of 75%. He deposited 18,75,000. I filed an application for release of that money to me.
Which is the application?
IA number 2 by I filed. I'm sorry, 3.
Yes, we'll allow that. In view of the.
My lord, if this bench does not think otherwise.
Pardon?
If this order may kindly be stayed for 4 weeks, if my party approaches. Because my lord, on the similar circumstances, the Honorable Supreme Court has. That Bharat Sanchar Nigam is with regard to section 6A, my lord. That is one.
Law is very clear. We know that. Yes. You know, what do you say on his request for 4 weeks?
4 weeks, my lord. Your lordship, I kindly see the date of award, my lord. 10/1/2014 is the date of award, my lord. Then he filed arbitration suit and dragged for 8 years. He did not argue the matter. But the arbitration suit was dismissed on 5/2/2020. He is before this court, my lord, after 2 years, 8 months of the dismissal of that. Now, when I file execution petition, when the notice is issued, he comes before this court, challenging the award of the arbitrator and also the order of the civil court. The interim order was Now, this granted court, only my lord, after hearing it, my directed, lord. well, that amount, my lord, which I have paid it to him in 2006, my lord. Now, at least to that extent, his interest burden will come down, my lord, if that amount is released to me.
He is saying 4 weeks. That's all. He say maybe he wants to take recourse to the appeal, let him take it. We will dismiss this.
Yes.
We can say that we will allow your application, but the same would be released after 4 weeks.
Please,
For them to work
much
it out.
please,
If they don't work it out, you will go.
please.
At this stage, learner counsel for the respondent has drawn our attention to an application being 3 of 23. Is the amount deposited, ma'am? Yes. Does it say so? States the state wherein the following prayer has been hit. Stop. The submission is that on the strength of on the basis of the order passed by this court on
29/5/2023.
29/5/2023.
23. Please.
The appellant number 1 has deposited an amount of rupees 1875,000. And the same be released in favor of the respondent herein. Full stop. On this prayer of learner counsel for the appellant, respondent, comma, the learner counsel for the appellant states that though the counsel for the appellant states that the effect of the order be stayed for a period of 4 weeks to enable the appellant seek a remedy of appeal before the Supreme Court, comma, we deem it appropriate to direct the release of the amount of 1875,000 with accrued interest, if any, in favor of the respondent upon proper identification in the presence of the counsel, but only after a expiry of 4 weeks. Expiry of 4 weeks from today.
Please.
Okay.
Great.
Right?
Yes.
You have 4 weeks, go, take a call. 4 weeks from today. With the
7
above,
judges bench, trial court relied on 7 judges bench. It's not your lordship.
You will say so before a higher forum. We have done our job.
Please.
Application disposed of.
Please.
Thank
Great.
you. Delay, how much is the delay?
174 days.
Allow, subject to, for the reasons stated in the affidavit. Yes.
Please.
Still number
Next.
13. Still number 13.
No, what does he want?
I wanted to carry out the correction.
Oh, man, just ask him to carry out the correction.
I will also file.
You file it?
No, I file.
Yes, 13. Say that none appears for. Did we also pass an order? There is no appearance for the appellant. We find that there was no appearance for the appellant on 5/8/24. The petition is dismissed for non-prosecution and in default.
Serial number 22.
Did you call the council?
It's,
Huh?
it's at serial number 22, and my lords were pleased to observe that some mention was made at 10:30 at serial number 11, which actually it must have been meant to serial number to be serial number
We
22.
presume so.
That benefit of doubt should go to the appellant.
That's the reason we made, we thought that the council will call the council who had mentioned it.
It's being displayed on the notice board that the counsel must appear before the court immediately.
What is the date given by us, ma'am?
11 comes.
11th?
11/12 December.
Mr. Veerabhadraya had appeared.
Beggar's pardon? Not
Counsel
Veerabhadraya.
had appeared.
Oh, serial number 11. Yes, yes. Well, it's a different counsel. Mr. Shiva Prakash is the appellant's advocate.
But he must have appeared in his place.
Prayer must have been made by a proxy counsel.
See, the other alternative, we have it on the same day, 11th of December. But he would be under the impression now date is 11th December, he will only appear on that day. We can't now even advance the date also in his absence.
The only the constraint for me to make this submission is the respondent is 75 years old, ailing, and his wife is also taking treatment for multiple complications. And there is a clear admission by them before this honorable court that they admit the liability to the extent of 34
We
lakhs.
can do one thing.
Please.
Just pass over. If we can make an attempt, let the council, briefing council make an attempt to call Mr. Veerabhadraya
Please.
and ask him, he mentioned matter in the morning in court number 2.
Please, madams.
Which matter he mentioned? Is he saying Bharat Heavy, this matter only?
Please.
Then ask him to be here.
Please. We'll do
Post
that.
lunch.
Please, madams. Please.
Then we can change the date.
Please, madams.
Okay.
Please. Obliged to your lordship.
Next, ma'am.
28.
Where is the council? Yeah, he's here now.
Please, sir.
Is it a without date matter?
It was initially without date, my lord.
No, the other one.
Both were without date. Yesterday, this matter got posted maybe in due course. And unfortunately, the connected matter ought to have been carried with it, did not come up.
But there is already an order for clubbing.
Lord, earlier when it was posted in 2023, both were coming.
Ma'am,
Was there any order for clubbing?
No such order, but both
Doesn't-
were coming together.
Your lordships are right, my lord. There was no formal order for clubbing. But what happens is if the matters are arising out of a common order and are also filed together, then usually they come up together, my lords.
just say this. Today, the learned, today, Mr. Bhatt has filed a memo stating that commercial, which is that matter, commercial appeal number
62, my lords.
62 of 2022, arising from the same award,
The same order under 34, my lords.
Order and award, both.
same award oblique order passed by the arbitrator oblique trial court is not be listed along with this appeal. Then a counsel appearing for the appellant agrees with the submission with the contents of the memo filed by Mr. Bhatt, and also makes a similar prayer that the said appeal be also listed along with this appeal. Since the said appeal is of the year 2022, be listed along with this appeal on be listed along with this appeal on date.
6/11, sir.
6/11, right? Hmm. Who has the arbitral record? Is anyone has?
My lord, it was in the arbitral center.
Arbitration center only.
My lord, this, the section 34 court did not summon the records.
So can we call the arbitral record from the arbitration center?
Yes, possible. It
They
is from the
preserve it,
arbitration
no?
center only.
Just say this, let the arbitral record in respect of matter number, in respect of AC number 93 of 2019 be requisitioned from the, this we call it at Arbitration and Conciliation Center, Bengaluru.
Yes.
That's right?
Yes.
Bracket domestic and international. Before the next date of hearing. Just give it after two
Look,
weeks.
there is an, in the list, it is stated that LCR is in the branch. Yesterday's list,
LCR is different.
One is arbitral record, one is 34 record. So what has
34,
come
there
is,
is no record, my lord, except this pleadings.
you're not understanding.
Yes.
That's right. So what has come is 34 record. We want arbitral record.
Yes.
Mr. Naganand on one of the earlier matters also submitting. Sometimes it becomes convenient for counsel to prepare a paper book if the documents are not voluminous.
See, to be at least talking about me is I expect that the councils must file the complete record. Otherwise, we are calling the record from the trial courts, we are burdening the space, or we are covering this case here, occupying the space here. So better would be make it part of the record, whatever pleadings you want to file.
Because that doesn't, we are before the High Court. There are unlikely to be any misgivings. Whatever my learned friend wants to rely on, if he serves a copy on me and vice versa.
If it is,
The other alternative, we call
but
for the
the
soft
copies I have, I can produce the copies, but it is better if it comes from the.
Very well. Okay. Thank you.
Obliged. Deeply obliged.
Give a date, man.
6/11.
6/11.
6/11,
My lord, 7, 6, there is another one, 7.
11.
Great.
Deeply obliged.
Seal number 30. Seal number 30.
Yes.
This is a case, my lords, wherein the arbitral award without having arbitration.
Without?
Having arbitration clause.
Just switch on the mic. Can you just switch on the mic? That's better. There is no arbitration clause.
With regard to appellant and respondent, there is an end user called a tenova, wherein the machinery has to be implanted. Installed. That is called painting and blasting blueprint. What exactly it is? Whenever the heavy machineries are prepared, manufactured, this painting and blasting booth uses for the surface cleaning and painting of the booth. It was the contract. My lords, exhibit P1, my lords, may kindly be seen. Page, my lord, 17 to 21. To find exhibit P1, it was the contract, my lord. Page number 17. Page number 17. Paper book 17, page number. Could find my lord, purchase order dated 22/11/2017.
Is it 70?
One seven.
17.
17.
Page number 17. That's
Exhibit
part of the trial court record. Trial court order.
Yes. It was exhibit.
Arbitration.
marked before the
Internal page. You are talking about
internal
internal
page.
page.
Which paragraph of that you are reading?
My lord, it is the entirety, the purchase order, my lord, is concerned. My lordship could find purchase.
See, we have a difficulty. We don't have the pagination here. We are going by the pagination, which is as per the bookmark.
Or you say paragraph.
No, it is a contract, it is a purchase order, my lord. There is no paragraph.
It's exhibit
Purchase
P1.
order.
Exhibit
P1 produced before the honorable arbitrator.
which is marked as exhibit P1 before the honorable arbitrator. Your Worship. Now, we want to know what is the page in the memo of appeal, in the appeal.
17. 17.
It's 17, my lord, page number 17. Paper book it is, my lord. Not appeal. It's not produced in the appeal memo. Only award was produced along with appeal memo. This is the paper book prepared.
What is paper? Oh. They filed a paper book. Yes. Oh, yes.
Please, my lord. Dated 22/11/2017. This is construed as an agreement, my lord. It is a contract. Based upon that, the claim was filed by the respondent before the before the arbitration tribunal. Here, my lords, in this page number 18, may kindly be seen, my lords. Terms. Lordship could find there are 9 terms, my lords, here. This 9 terms, first term is concerned, first term is considered as a advance, my lord. Second term is the second installment, the payment mode, etc., etc., etc. And fourth is the last and final payment will be made on completion of the successful erecting and satisfaction report from the customer and end user. That is a tenor, etc., etc. Here, my lord, there is no arbitration clause. My lord, the claim petition.
How was the arbitrator appointed?
No, it was initially they went to MSME, my lord, the MSME mediation.
This
was
is,
paid.
this is MSME.
MSME.
So you are governed by the MSME Act.
Yes, sir.
Please.
There is a statutory arbitration.
Yes, sir.
That's it.
No.
We are governed by the section 18(3) of the MSME Act.
That's what we are putting it to you.
Yes, please. MSME did not refer for arbitration. And the mediation was failed.
The council did not refer. How was the arbitrator appointed? We want to know.
Arbitrator parted by the consent of both the parties.
No, Lordship.
So you consented.
Yes, consented for the arbitration.
Then why are you saying that there is no arbitration clause?
No, there may have an objection before the arbitrator saying that this court has, this tribunal have no jurisdiction to entertain this arbitration proceeding.
But what is the effect of the consent given to for appointment of arbitration?
Only with regard to the appointment of the arbitrators, they approached it before. They filed a claim petition. I appeared. I said, okay, it can be appointed. I said,
Okay.
this court cannot decide it. This arbitrary tribunal cannot decide it because of arbitration clause.
On what ground?
There is no arbitration clause, my lord.
Very well. So what you are saying is now who would appoint the arbitrator? If this tribunal or that arbitrator who has been appointed cannot decide the dispute, then who would decide the issue?
Competent jurisdiction, my lord, civil courts. If any dispute they have.
So you have given a consent. Where is the question of civil court going back to civil court? You have given a consent?
The appointment of the arbitrator.
So that
can give an
consent, that is something in terms of section 7 or may not be, there was no written agreement between you, but a consent was given.
Yes, please.
So very well. So on the basis of this, the parties have acted.
Yes.
Now, where is the appointment of the arbitrator? Is there any letter that so-and-so is appointed as an arbitrator?
No, my lord. It's oral.
Who did you appoint? You appointed?
Actually, I'm covered under the MSME sector, Your Honor, and I come under the MSME sector. And parallel, I'm protected under the provisions of MSME Act. When there was no payment made from his side, the client side, I approached the MSME council requesting for a negotiation. Since the negotiation failed, under section 18(3) of the MSME Act 2006, it was referred to the arbitrator. It was a statutory reference.
By the MSME council?
Yes, ma'am.
Where is that appointment?
Section
letter?
18(3) is very clear.
No, forget that. Where is the appointment letter?
It is there in the arbitration. Since it is an statutory reference, Lordship, the arbitration agreement is also not required. It mandatorily says that.
But there must be some council order.
Yes.
Where is that we want to know?
Is not produced.
Here in the booklet, it is not produced, Your Lordship. If
Order is there.
Where is the first proceedings of that council of that arbitrator? He must have said, I've been appointed so and so.
page number 78, Your Lordship, booklet. In the award, first para itself says that Micro and Small Enterprises Facilitation Council has referred this case of arbitration void its order dated 22/8/2019.
Okay.
Page number?
78, booklet, Your Lordship.
In the award.
The award it
We'll
starts
come back
commences
up.
with that word only. The award it commences with that word on wording. Also.
Your Lordship's kind permission, my lord, kindly, one memo for being spoken to, my lord, one matter was dismissed on 15th, my lords.
File an application.
Being spoken for dismissal. Dismissal agreement being spoken after. It was some question of law is in.
File an application.
My lords, kindly, my lord.
Was it dismissed?
Yes, my lord, it was dismissed, my lord, it was the notification of the year 2011, my lord, it is the land acquisition matter, my lord.
But will it come here?
Arbitrator has passed an order.
File a proper application and you must see which court has the jurisdiction.
My lord, kindly, my lord.
Right.
I make a submission. But respect of serial number 31, my lord, is passed over matter. But the senior council has got some inconvenience in the afternoon, my lord.
Who appears for the other side?
Pass over, my lord.
We passed over, but synopsis is not, we prefer synopsis to be filed. I represent,
Just the other side comes. Is someone appearing in this?
I have some difficulty.
Oh, they sought a passover. Let the council call the council. If both she is agreeing, then I think you can take a date. Okay.
Madam.